As you've requested, basically, members, the last time we met was on the 13th of November, 2020, and we had 58 submissions which were officially tabled to the committee. In terms of those 58, we were able to process and eliminate 33, which we said belonged into a category 1. And that category 1, it denoted submissions which did not fall into the committee's mandate. We also then, I just want to skip, we had category 2. We agreed that category 2 would be those submissions that require a legal opinion because they were technical in nature and required us to apply our minds before we decide as a committee how to move forward in terms of their desirability to amend the Constitution. Of the category 2 submissions, we had 10 of them. Members will then remember that we had one of those of the 10 was from equal education. It was also a submission pertaining to section 100. We had a legal advisor brief us already on that one. We also had equal education to brief the members because this was a submission which was emanating from the previous parliament. Today, we will be hearing now the rest of the legal opinions, which is 9 legal opinions. We also then have category 3, which we decided on. Those submissions were the ones which the committee decided they were ready for consideration. Those submissions we processed on last year on the 11th of November, and the committee had decided there was 11 of them categorized under category 3. We found that some needed to be referred to the appropriate committees, and we found that some were undesirable. So all in all, the ones with the potential of perhaps deciding on amending the Constitution fall into the category which will be decided today. I've then supplied this document that I'm speaking from to members. It provides a summary which from page 3, we will then see the recap of the ones which we will be receiving the legal opinions for. So basically, we have submission 2, which is on Chapter 9 institutions, and it called for an addition of a Chapter 9 institution, which would be the Commission for Internal Auditors. We also then had submission 6 from Andries, which was a review of the accountability provisions in the Constitution. We will also then receive a briefing on submission 32 of 2020, which was a review of section 6 on the addition of Kilovedu as the official South African language under section 6.1 of the Constitution. We also then had submission 33 of 2020, which was from the South African Secular Society, which requested the committee to consider the removal of the reference to God in the Constitution. Moving on to number 6, under the category 2 submission, we have submission 36, which was from Paul Hoffman. Paul Hoffman requested the committee to insert a new Chapter 9 institution, which is aimed at eradicating corruption. Moving on to number 7 of the category 2 submissions was the equal education one, which I've already spoken to. Therein, members discussed briefly after receiving the legal opinion, and they found that there was lack of clarity in the roles and responsibilities, and this led to confusion and it diminished accountability amongst the state organs during the Section 100 interventions. This was found to be detrimental and it affects the parties. Members have then said that they recommended that this submission be forwarded to basic education for further consideration. We then moving on to the second last one, which is legal number 8 on submission 53 of 2020 from Justin Bellot. Justin requested a review of various sections spanning from section 1 to 11 right through to 38. And he needed a clear constitutional limitation on government during the state of national disaster. So he wanted there to be an insertion made into the Constitution in order for there to be this provision. And then we have the last one, which we will receive a briefing from legal today, was from Romalo Naidu. And he requested also a various number of sections, which legal will then present before the committee. So what remains now is that the committee must decide on the desirability of these 9 remaining submissions, which we will receive the legal opinions for. And then the committee will then receive a report of the submissions that it is considered for the 2020 year and the ones stemming from the legacy. Thereafter, we will then table our report, which closes the chapter on the 2020 submissions and those stemming from the previous parliament. Thank you, Chairperson. I hope that assisted.
It adds this, you have really assisted the committee a lot, as we have discussed, colleagues. Pilot, I want also you to assist us about our... Okay, thanks, Comrade Taba.
My apologies, your bandwidth is low. Maybe if you could switch off your video, it could be better.
Okay. No, thanks so much, members. How is now? Is it much better? Is it better, Masha?
Yes, I think it's better. I can hear you from my side.
Okay, no, thank you. I'm saying maybe Pilot, can you assist us to tell us who have joined us today in the panel, so that we can acknowledge them accordingly.
Maybe Chair, because some members have logged in with names that are with gadgets that do not reflect their names. But I see here the majority of members are present, Chair. Maybe
I'm meaning the guest. I'm meaning the guest. I can see members that are here.
Yes, I've got about 24 participants.
Guests.
Yes, Chairperson, there is a couple of people who are here.
Yes.
Yes. Maybe
I don't know. Thanks. It's just that on my side, quality education and other guests are here. Are they here, Pilot?
I did not get a specific indication on who is here for, but I can see someone from PMG, but others are people who have requested, but they have not indicated. Maybe you can ask them, those that are not our guests, to introduce themselves. Maybe, Chair, that could assist. But I wanted to bring it to your attention the apology from the co-chair, who said he is struggling with network. He will join us as soon as his connection issues are sorted.
Okay, no, that's fine. That's fine. Maybe colleagues and our guests, it would be important that we identify ourselves, especially our guests in the platform, so that we know who are here. May you introduce yourself? Just in mute, Comrade.
Good morning, Chairperson, honourable members, and everybody on the platform this morning. My name is Kilovedu and I'm from Parliament's Legal Services. I will be going through the first legal opinion on the list. Thank you, Chair.
Thank you very much. Another guest.
Yes. Morning, Chairperson and honorable members and colleagues. My name is Andile Tejan. I'm from Legal Services. I'll be dealing with the second opinion on the review of accountability provisions in the Constitution. Thank you.
Good morning.
Thanks, Andile. Who else is here?
Good morning, Chairperson. This is Fatima Ibrahim, also legal advisor in the Legal Services Office, and I'm dealing with the third submission in respect of declaring the Kilovedu language as an official language. Thank you, Chair.
Thank you, Fatima. You're welcome. Pumelele.
Good morning, Honorable Chair and all the members and everyone on the platform. My name is Pumelele Ngema. I'm also with the team from Legal Services and we'll be doing number 4 of the presentations. Thank you, Chairperson.
Thanks, Pumelele. Who else is here?
Good morning, Chair. It's Mohammed Dango here. Just to say, I've logged on a device that's not in my name. So please excuse me for that. My own device is flat. Thank you very much.
No problem. We wanted our guest first. Honorable Dango. And let's go to Siviwe.
Good morning, Chair and honorable members and colleagues. I'm
Siviwe, do you hear me?
Yes, I can hear you, Chair. Good morning, Chair and honorable members and colleagues on the platform.
Yes, you'll be doing.
I will be doing the submission by Advocate Paul Mann on the establishment of a new Chapter 9 institution to deal with grand corruption. Thank you, Chair.
Thank you, Siviwe. Any other one, honorable members?
Hello, Chair.
Yes, yes, Lloyd.
Good morning, Chairperson. I'm Barbara Lewitz. I'm also from Legal Services, and I will be dealing with number 8, which is various submissions by Mr. Ballard. Thank you, Chair.
Thank you so much, Lloyd.
Thank you.
Isaac?
Good morning, Chairperson and members. My name is Sue Ann Isaac, and I will be dealing with number 9, also by Mr. Justin Ballard. Thank you.
Thanks, Mrs. Isaac. Any other one, colleagues? Thank you very much. Everyone who has introduced himself, I can see members are all here, and those that are not here, let's get an apology from Pilot for those that are not here.
Thank you, Chair. I received an apology from Dr. Mulder, Professor Lotrit, those should be the 2 apologies that I received, Chairperson. The professor has joined us. He's now on the platform.
The professor, thanks so much. The co-chair, I don't see the co-chair.
I'm here.
Oh, thanks, doctor. Thanks, doctor. Okay. Colleagues, now that we do have a quorum, I suggest that let's zoom straight to firstly finalize. Maybe I don't think if it's in order to start with the minutes instead of starting with everything else and end with the minutes, because the minutes will only need members.
Chairperson.
Yes, somebody was saying something.
Chair, Matola here.
Hello.
I thought that because the minutes will need a quorum.
I suggest members that let's. Yes, Chair. Co-chair.
I was suggesting that let's start with the minutes because they need a quorum in case some of us disappear because of the network.
Okay, that's a suggestion. Is it all agreed?
Chair. Chairperson.
Supported.
Chairperson. Chair.
Chairperson, there is a hand from Honorable Kondo.
The co-chair have left the platform. I think Chair Matola
I'm here. Oh, I'm here. Honorable Gondwe, can you proceed?
I just wanted the committee to note an apology from Honorable Mikilakis.
Thank you. Yeah, thank you. Can we proceed to the minutes? How many sets do we have?
We have got five sets, Chairperson. I'm going to start with the minutes
through.
of. Okay. Chairperson, I'll start with the minutes of 2 September 2020.
Yes, proceed.
So this is the first picture.
Okay. Any corrections there? No corrections, proceed. First paragraph, opening, any correction? Second paragraph, workshop on the role, any correction?
Hello, Chair.
Yes.
Yes, it's Cyril Klaba here.
Hi, Comrade Cyril.
Hi, Chief, how are you?
I'm well, thank you. I just see you in the
Very
newspapers
good.
now.
Oh, okay. No, you know, I see that I'm registered as having tendered an apology in all the meetings. But for example, this one that was discussing the legacy report, I get sure that I was present. I don't know how to verify that, Pilato, so that I don't come back again to say I was also in this meeting. Is there? Can you verify?
I think it should suffice for you just to place on record that you were there. Then we can do the rest. Yeah.
Okay, that's fine. Can I place it on record that I was in this meeting? Thanks.
Yeah.
Thank you.
Proceed.
Sure.
Thank you. Advocate, proceed. Paragraph 3, any correction? No, none. Paragraph 4, any correction? None. Paragraph 5, no correction. Paragraph 6, no correction. Closure. Can we get a proposal for the adoption of these minutes? Honorable members?
Chair, I move that we adopt.
Yes, I move adoption. I move adoption of the meeting.
Thank you very much. The minutes are duly adopted. Advocate, can you move to the next set?
Okay, Chairperson, I'm gonna do that quickly.
Are you still doing it quickly?
Yes. Just my apologies. Okay, Chairperson, the next set will be the minutes of 9 October.
The 9th. Okay. Let's see. Okay, go up. Any corrections?
Maybe Chairperson, just to highlight, I'm going to request my colleague to assist me with the register so that I double check the attendance register of all the members to verify.
We don't have to do a verification. Any member who is missing can just place it on record, as Honorable Skaba did. Then paragraph 2, any correction? 1 and 2, any corrections? None. 2.1.2, any corrections? Paragraph 3, any corrections? Paragraph 4, any corrections? Paragraph 5, any corrections? 5.1, any corrections? Paragraph 6, any corrections? Paragraph 7, any corrections? Paragraph 7, any corrections? Closure. No corrections. A proposal for the adoption of the minutes. Honorable members, can we get a proposal for adoption of the minutes?
Chair, my name is Mama Temba. I move for the adoption of the minutes.
Thank you, Comrade Noma Temba. Sir, I can't see there's another hand for seconding. Who is that?
It's the co-chair.
Or seconded, so minutes are duly accepted, adopted. Advocate, can we move to the next set? Advocate? Advocate Gwebu?
I'm here, Chairperson. I'm flighting
Can
it
we
now.
move to the next set?
Yes.
Okay. You disappeared again.
I'm here, Chairperson. I'm just a bit struggling with the. Okay, there we go, Chairperson.
Okay, honorable members, agenda there and the attendance. Any correction? Proceed. Any correction? Paragraph 1, 2. No corrections. Proceed. Or the meeting is adjourned. No corrections. Can we get a proposal for adoption? Honorable members, can we get a proposal for adoption?
Chairperson, I propose for the adoption.
Chairperson. Yes.
I am seconding I'm seconding the proposal for the adoption, Chair.
Who are you?
Andiva Mhlekazi.
Oh, begithi ubani yakhulumayo?
Oh, into kaMkhiva le uRhenqwa Gcwanini uSibeki.
Oh, okay, okay. Thank you very much. I hope you get out of the cold, because you sound you have some slight cold. Thank you very much. The minutes are duly adopted. Advocate, can we move to the next?
Thank you, Chair. The next minutes will be the minutes of 3rd November.
Yes, there is the agenda and the attendance register. Is that all in order? Let's proceed. There we are. Paragraph 1, 2. Any corrections? None. Paragraph 3. None. Paragraph 4. Paragraph 5. Paragraph 6. Closure. No corrections. Can we get proposals for adoption?
Nomathemba Maseko Jele, I move for adoption, Chair, of the minutes.
Thank you, Comrade Nomathemba. Any seconder?
Chairperson, just one correction. My name is spelled with an R at the end. It's not just D-A-N-G-O. Thank you.
Comrade, Honorable Mohammed, we will correct that. And,
thank you.
That's in order. Are you seconding?
I'm seconding.
Thank you very much. The minutes are duly adopted. Advocate, can you move on?
Thank you, Chairperson. We move on to the minutes of 27 November. I will be highlighting them. Okay. There we go.
Okay, honorable members, there's attendance register. Is that all in order? Proceed. Paragraph 1, 2, and 2, 1. Any corrections? 2, 2. Any corrections? Proceed. 2, 3 to 2, 5. Any corrections? None. Closure. Can we get a mover for adoption? Honorable members, can we get a mover for adoption?
Chairperson, I move for the adoption of the minutes.
Thank you, honorable member. Any seconder?
Chair, I second Maseko Jele.
Thank you, honorable Jele. The minutes are duly adopted. Advocate, any other set of minutes?
President, these were the 5 sets of minutes that were outstanding. We can now proceed.
Thank you very much for very good minutes, and we are happy that they are all been adopted, because the chair of chairs had instructed us not to do any further work before we adopt these minutes. Now we are in compliance, and we move to the next agenda item.
Chairperson, the next agenda item would be the briefings from the legal services. I did not receive. Maybe they can indicate who will start first, so that I can make them a call, so that they can fly if they have a document that.
Is the briefing on the legal opinions?
Yes.
Or on what?
Remember, Chair, we have got 9 legal opinion presentations that we're going to receive today. That's the main agenda, in fact, of today's meeting.
Were they circulated to the members?
No, Chairperson. The opinions themselves were circulated to the members, but I don't know if they will speak to the document that that was circulated, or they've got maybe PowerPoint slides. That's what
okay,
I'm not sure.
Let's hear from them what's the suggested approach. Can you first talk to us about your approach?
Chairperson, maybe before, with your permission, I wanted maybe the committee to decide whether after each presentation, the committee will deliberate and make a decision, a determination on the desirability, or the committee wants to receive all presentations and then deliberate on them.
Let's hear the approach first, and then we come to what we are saying. That lady.
Thank you, Chairperson. I think our approach from legal will literally be, as we understand it, the opinions have been circulated to members. So what we will do is we will literally just speak to our opinions.
Okay, so that shouldn't be long, but I think as Advocate Pilot suggested, we must do them one by one so that we don't confuse members. Yeah, proceed with the first one.
Thank you, Chair. Chair, with your permission, I'm going to switch off my video and
yes.
I'm going to proceed. Thank you, Chairperson. Our office was requested to advise the Joint Constitutional Review Committee on proposals received concerning various matters. By way of background, the chairperson of the committee received, amongst others, a submission on the 11th of May 2020 proposing that a 10th institution be added. I was requested to provide an opinion on the statutory appointment of internal auditors. The proposal speaks to the desirability to bolster our constitution by adding a 10th Chapter 9 institution called the Commission for Internal Auditors. The proposal, in summary, suggests that by adding the institution of internal auditors, it would render internal auditors independent of boards and management. And in doing so, it envisages that internal auditors' reports will form part of the organization's annual reports. And once part of the annual reports, government, shareholders, and the public will have access to internal auditors' reports. The upshot of this proposal is that government and shareholders will be in a position to retrieve their governance roles that have been abdicated to different organizations, and government will be able to fully govern through the constitution based on the ongoing feedback by internal auditors. So it's submitted that through these comprehensive organizational reports, the public will be in a better position to hold government accountable. The submission goes further and says that by creating the additional institution, it will allow for internal auditors to focus on preventative controls, which will then relieve the Auditor General to focus on detective controls. In order to gauge or assess whether the proposal is feasible and or necessary, it is required that we go through our existing regulatory framework. So in other words, what do we have in place currently at our disposal? Our starting point should always be the Constitution. Section 59(1) of the Constitution provides that the National Assembly must facilitate public involvement in the legislative and other processes of the National Assembly and its committees. Section 195 of the Constitution sets out the basic values and principles governing public administration. Here we talk of a high standard of professional ethics, we talk about the effective use of resources, we talk about services must be provided impartially, fairly, equitably, and without bias. We talk about accountability and transparency. The above Section 195 principles apply to administration in every sphere of government, to all organs of state, and to public enterprises. Now that I've dealt with the pertinent parts of the Constitution, I will turn to our rules. What do the rules of the National Assembly say in this regard? Rule 2271B provides that a portfolio committee must maintain oversight of the National Executive Authority and of any executive organ of state falling within its portfolio. Rule 2271C goes on to say that a portfolio committee may monitor, investigate, and inquire into and make recommendations concerning any such executive organ of state. Chapter 9 of the Constitution establishes the Auditor General of South Africa. We know it as AGSA, as one of the state institutions supporting constitutional democracy. The Constitution acknowledges the importance of AXA and guarantees the independence of AXA, stating that AXA must be impartial and must exercise its powers and perform its functions without fear, favour, or prejudice. Section 181(5) of the Constitution, together with Section 3D of the Public Audit Act, stipulates that AXA has to report to the National Assembly on its activities and performance of its functions, and Section 188 of the Constitution and the Public Audit Act regulate the functions of AXA and authorizes AXA to perform constitutional and other functions. Section 188 of AXA, Section 188, of the Constitution lists the functions of AXA. It says that the Auditor General must audit and report on the accounts, financial statements, and financial management of all national and provincial state departments and administrations, all municipalities, and any other institution required by national or provincial legislation to be audited by the Auditor General.
Before you proceed.
Yes, Chair.
This is the document that you circulated.
It is the opinion that we circulated.
Now, I thought that the purpose of circulating is that members would read, and then we would take it as read and give members an opportunity to, express themselves on the opinion, other than you repeating what they have already read. But I stand to be corrected. Yeah. Let's hear what the members are saying. Honorable members. Honorable members.
Yes, you correct, Chair, is Enoch Mteto. You correct, Chair, but what we need to do is that let's get the presentation today. And the committee will then take a decision whether it's desirable or not. But what we need is just to get this opinion together so that when we adopt or when we do, we will ensure that we capture this view. I suggest, Chair, that he can talk to the views, and then we will definitely finalize it after that.
Okay, thanks for helping us through, Co-Chair. Proceed, Advocate. Can the presenter proceed? Yeah.
Thank you, Chair. I stopped on Section 188, where it lists the functions of the mandatory and the obligatory functions and the discretionary functions of the AG. So the AXA is accountable to the National Assembly, and it is obligated to report on its activities to the National Assembly. So the primary accountability mechanisms of AXA is their annual budget and their strategic plan, both of which are tabled in the National Assembly. Section 188 further stipulates that AXA must annually produce audit reports on all government departments and public entities, municipalities, and public institutions. Over and above the reports on discretionary audits, performance audits, and other special audits are also done. An internal audit framework was developed by National Treasury during the 2003-2004 financial year, which sought to establish a minimum guideline for internal audits in the public service. The PFMA and the MFMA both make provision for the establishment of an internal audit activity, which assists accounting officers in the discharge of their responsibilities. Our understanding of the proposal is that internal auditors are appointed by organizations on an ad hoc basis. And many organizations, the proposal goes on to say, may not have internal auditors in their governing structures. The analysis in AXA's general reports, which are accessible to public, are aimed at refining the state's overall management of financial management and improvement of service delivery. In order to re-establish accountability, AGSA introduced preventative control guides, which assist institutions to address their main areas of risk. Internal controls, such as preventative controls, detective controls, and corrective controls, are all focused on identifying and correcting failures that have already occurred. The Public Audit Act has recently been amended to introduce the concept of material irregularity. So now when AGSA performs an audit, the audit must satisfy themselves through a host of tests and checks and balances to ensure that the entity is not exposed to the risk of fraud, which could result in financial loss. Once the material irregularity has been identified during an audit, AGSA is authorized to refer any material irregularity to the relevant public body for investigation. Our advice to the committee, in our opinion, it says that the concerns, it appears that the concerns raised are already addressed in other legislation, and that the addition of a 10 Chapter 9 institution will have financial implications of having to employ additional people to head and work in yet another Chapter 9 institution. My advice to the committee was that the committee may want to consider addressing correspondence in reply to this proposal, advising that the concerns raised in this proposal are sufficiently dealt with and provided for in existing legislation. Thank you, Chair.
Thank you. Honorable members, we agreed that we will take these opinions one by one. So this has been concluded. What is our position to the recommendation made?
Chairperson, through you, I'm not sure whether I heard the co-chair properly, but whether he was suggesting that you make the decision at another meeting. I was under the view that the committee will decide after receiving the briefing and the recommendation whether it agrees or it doesn't agree, so that we put the matter, we conclude the presentation today.
If that's what the co-chair said, I would have agreed with him, because maybe we need time ourselves to deliberate on the opinion, because now we could just be rushing to adopt without applying our mind. But let me hear the co-chair exactly what he was suggesting. Co-chair? Co-chair?
There's a hand from Dr. Gondwe, Chair. I think the co-chair may be having
yeah, let's say Dr. Gondwe. Dr. Gondwe.
Thank you very much, Chair. I was just going to confirm that indeed the co-chair suggested that we receive all the legal opinions today, because I think there are 8 of them, and then we give our indication on whether we agree with the recommendations made in the legal opinion. Chair, and I want to just raise a concern. We received these opinions on Tuesday, and we had, just a couple of days to go through them. So it's quite a lot of reading to do. And there are 8 of them. So I do agree with the suggestion by the chair, by the co-chair, that perhaps we hold over around considerations on the desirability of the proposed amendment to a next meeting. Thank you.
Honorable members, I tend to agree with Honorable Gondwe that today let's just receive the opinions, and then step number 2 would be then to have a discussion on each one of them to determine the desirability or otherwise. Is there any member who is not happy with that? If we are happy with that approach, can we go to the next opinion?
Good morning. Good morning, co-chairpersons, honorable members and colleagues. My name is Andy Letekian, as I indicated earlier. To you, Chairperson, if you may allow me also not to switch my camera on. Thanks, Chairperson. Chairperson, I won't rehash what the opinion says. I think I'll just be 5 minutes. My opinion, Chair, is on the review of accountability provisions in the Constitution.
Honorable member. Honorable member. Hello?
Yes, Chairperson.
I thought what we wanted, we were suggesting is that we don't discuss anything now. We just note the presentation, and at the next meeting, then engage with the presentation opinion. Are you happy with that?
Are you referring to me, Chairperson?
Yes.
Chairperson, this is a second opinion that is being presented, so it will also be presented and then noted by the committee.
But the speaker on the platform, I thought he was commenting on the first opinion.
No, Chair. He's giving us the second opinion.
Oh, I see. No. Proceed. I'm sorry. Proceed.
Thanks, Chairperson.
Before, Chair.
Yes, Honorable Jelen.
Chair, thank you very much. Chair, I think before the presenter can even go far, I hear him saying he's going to summarize it for 5 minutes. I think, Chair, if we can follow the same what the first presenter did, 5 minutes would not give us exactly what that presentation is saying. I think he must reconsider that, Chair, because we are here.
I agree with you. Honorable Jele, I agree with you. It's not up to him to consider. He must do as you propose, as the first one did. Proceed. Yes.
I'm happy with that, Chair. I'm happy with that.
Okay.
Chairperson, our office was requested by the chairpersons of the Joint Constitutional Review Committee to provide a legal opinion on the review of accountability provisions in the Constitution as part of the constitutional review process. We were required to look at whether there is a need for such a review and advise accordingly. On the 21st of May 2020, Mr. Andries Havenga submitted that there must be a specific accountability provision that must be built into the Constitution, in which politicians and senior officials can be forced to resign or can be suspended immediately in the event of questionable conduct of a serious nature. In addition, Mr. Havenga is of the view that a cursory reading of the Constitution reveals that the Constitution is flawed in that the accountability of the President and Cabinet is dealt with in a superficial manner. Furthermore, Mr. Havenga submits that it is not clear what the exact grounds of removal of the President are under Section 89(1)(b) of the Constitution. He makes mention of the fact that nowhere is the suspension of the President in certain circumstances stated in this section. Moreover, Mr. Havenga avers that there is no consequence management that flows from non-compliance with Section 96 of the Constitution by members of the Cabinet and Deputy Ministers. Mr. Havenga opines that the elephant in the room is the fact that there is no specific provision in the Constitution in which a President, member of Cabinet, or member of Parliament, against whom a prima facie case of serious misconduct has been made, can be suspended from office pending a final decision by courts or an administrative body. As a consequence, Mr. Havenga suggests that Section 19 of the Constitution should be amended by way of an addition of subsection 4 in the following manner. This section, Chair, deals with political rights. I'll just go to the addition which the member of the public is suggested, which is Section 19, subsection 4. Every citizen has the right to transparent and accountable governance by government. Mr. Havenga's view is that the Constitution must give more protection to the citizens of the country against elected members of Parliament who, once elected, have no obligation other than within their political party structures to be accountable to the people who elected them. Now, this opinion is solicited in the above mentioned context. Now, Chair, what I want to say is, perhaps let me preface my presentation by saying that in order to have a thorough understanding of the foundation of South Africa's constitutional project, one requires a thorough reading and understanding of the certification judgments. Now, in these two judgments, Chair, the Constitutional Court convened to consider whether in each of the provisions the Constitution complied with all 34 constitutional principles that had been debated and finally agreed at the Constitutional Assembly, comprising all political formations in the country. You will recall, Chair, that prior to the ushering in of the Constitution of the Republic of South Africa 1996, there was an agreement which was taken by the Constituent Assembly to say that there were 34 constitutional principles which the Constitution, the final text, should comply with. And you will recall that there were two Constitutional Court cases, Chair. The first one, you will remember that the Constitutional Court declined to certify the Constitution. It only did so in the second one. Now, that task, Chair, was an onerous one. It entailed the court measuring each and every provision of the new Constitution, viewed both singly and in conjunction with one another, against the stated constitutional principles, irrespective of the attitude of any interested party, and then not only recording its conclusions regarding that exercise, but also making plain its reasons for each such conclusion. Now, of significance is the fact that everyone was invited to provide any objection she or he may have to the certification of the new Constitution and the basis for that objection. In the result, Chair, the court heard oral argument over a period of 12 days in July and November 1996. Now, the point I'm trying to make here, Chair, is that you had academics, you had members of civil society looking at the Constitution, making objections, being guided by the 34 constitutional principles. That's why, Chair, we say it was a very involved and rigorous process. Now, Chair, perhaps let me start at the end, Chair, because I was taught that sometimes it helps the audience to start with the conclusion. Chair, to quote the late Professor Etienne Murinik, my submission, Chair, is that if you look at the Constitution as it currently stands, Chair, it fosters a culture of justification, Chair. And I will elaborate on that, Chair. We say, Chair, the principle of accountability, Chair, is one of the founding values of our Constitution. And if you look at the proposed constitutional change, Chair, my sense, Chair, is that this important principle is being relegated to Chapter 2, which is Section 19 of the Constitution, which deals, of course, with political rights. Now, Section 1 of the Constitution, Chair, of the Republic of South Africa, particularly Section 1D, says the Republic of South Africa is one sovereign democratic state founded on the following values. I just quote teacher: universal adult suffrage, a national common voters' roll, regular elections, and a multi-party system of democratic government to ensure accountability, responsiveness, and openness. Now, Chair, we make the point that this is one of the highly entrenched provisions, Chair, because it is part of our founding values. Section 1, read with Section 74(1) of the Constitution, states that it requires a 75% majority in the National Assembly and a supporting vote of at least 6 provinces if these values are to be changed or taken away. Now, Chair, if you look at what the member of the public seems to propose, we say, Chair, that this foundational value, it permeates every nook and cranny of our entire constitutional scheme, Chair. If you speak about supremacy of the Constitution, you speak about accountability. If you speak about the doctrine of legality, you speak about accountability. If you're speaking about the doctrine of separation of powers, you're speaking about accountability. If you're speaking about the intergovernmental relations framework, you speak about accountability. If you speak about financial management of public finances, you speak about accountability. If you speak about oversight functions. Sorry, sir.
I said etc. etc.
Yes, sir. Okay, sir. That's why I didn't want to bore you, sir. I wanted to summarize. Okay, sir. In addition, Section 41C of the Constitution provides that all spheres of government and all organs of state within each sphere must provide effective, transparent, accountable, and coherent government. Now, Chair, in the Nkandla judgment, Chair, you will recall that the Constitutional Court said one of the crucial elements of our constitutional vision is to make a decisive break from the unchecked abuse of state power and resources that was virtually institutionalized during the apartheid era. To achieve this goal, we adopted accountability, the rule of law, and the supremacy of the Constitution as values of our constitutional democracy. For this reason, public office bearers ignore their accountability and the rule of law, constitute the sharp and mighty sword that stands to chop the ugly head of impunity off its stifled neck. Now, Chair, there's a plethora, Chair, of case law in our jurisprudence, Chair, which puts paid, to the idea that even members of the executive, Chair, when they're exercising their executive authority, they can't just do, Chair, willy-nilly. You will recall, Chair, in the Albert case, Chair, which dealt with Section 84(2)J of the Constitution, because that section empowers the President, Chair. It gives the President the power to pardon offenders. Now, you will recall that the Constitutional Court had to determine whether procedural rationality required the President to consult with victims of political crimes before considering whether to pardon the perpetrators of these crimes in terms of a special presidential dispensation. And you will recall, Chair, that because the President, despite the fact that the Constitution empowered him to do so, but the court said because he had not given the victims the Audi rule, that decision was set aside. Now, you will recall, Chair, again that in the DA case in 2013, and that case dealt with Section 179(1)(c) of the Constitution, the power of the President to appoint the National Director of Public Prosecutions. You will recall, Chair, that even in that case, Chair, the Constitutional Court held that the President, by not taking into account the findings of the Chinwala Commission, ignored a relevant factor, and as a result, Chair, that decision was set aside. In 2017, Chair, again in the DA case, you will recall, the Gauteng Provincial Division, the High Court in Pretoria, held that executive decisions have to be rational. It is now settled law that these decisions must comply with the doctrine of legality. And this Chair dealt with Section 91(2), which is the President's constitutional power to appoint and dismiss ministers. Now, that's why I started, Chair, by saying our constitutional scheme fosters the culture of justification, because the President there was told in no uncertain terms that he needs to furnish reasons for the decision. Chair, without wasting your time, we say that the national executive's accountability to Parliament is not limited to cabinet. It extends throughout the national executive, for instance, to deputy ministers in terms of Section 93, subsection 2, the state institutions supporting constitutional democracy in terms of Section 1815, the public administration in terms of Sections 195(1)(f) and 196(5), and the security services in terms of Section 199(8). Now, Chair, if you go to page, I think to page 7, Chair, of the opinion, you will see there, Chair, that we list, Chair, a suite of legislation, Chair, which we refer to as an anti-corruption legislative framework, Chair. We list no less than 15 pieces of legislation, Chair. We also say, Chair, that if you look at Section 6 of the Executive Members Ethics Act, that section, Chair, addresses the principle of equality before the law and prescribes that nothing in this act may prevent or delay prosecution of a cabinet member, deputy minister, or MEC in a court of law. And as you know, Chair, in terms of Section 91(1), the Constitution provides that the word cabinet refers to both the President as the head of the cabinet, the Deputy President, and his ministers. And Chair, we also want to make the point that you will recall that this year, Chair, on the 8th of June 2021, President Ramaphosa placed the former Minister of Health, Dr. Zwelini Mkhize, on special leave as a result of the digital vibes allegations. Our view, Chair, in conclusion, is that we see no need, Chair, for those accountability provisions to be reviewed. In fact, the case we make, Chair, is that one has to delimit or delineate between a power which is there in the Constitution and not exercised by those who are entrusted to exercise. And I think if you read the Nkandla judgment, Chair, you will agree with me that the court was very scathing on the National Assembly on the fact that they could not hold the president accountable adequately. Chair, I will end there. We say, Chair, in view of the above, it is our concise opinion that there exists no need to review the accountability provision in the Constitution. We say, as previously advised. Yes, Chair.
Thank you very much. Well done. That's a well done. And a good opinion is noted.
Thank you.
Okay. Honorable members, shall we move to the third opinion? Advocate?
Yes, Chair.
Thank you, Honorable Jelen. Advocate.
Good morning, Chairperson. This is Ms. Fatima Ibrahim. Chairperson, I dealt with the opinion 32 of 2020, which was a request by Mr. Koso Selowa, who represents a non-profit organization. And the request is that we declare the Kilovedu language as an official language. Now, members will be aware that it is a dialect of Northern Sotho. It's spoken by the Balobedu tribe, which is proudly the only queendom in South Africa and is as famous for the Rain Queen. So most members will be familiar with that. In support of the submission, Chairperson, Mr. Selewa notes that in 2018, a comprehensive Kilovedu dictionary and orthography were produced. And currently, they were in the process of also developing a picture dictionary and have also found written examples of the Kilovedu language. And the reason that this is important, Chair, is that previously this language has been considered as an unwritten language form. So of course, if a language is unwritten, that's going to impact whether it's possible to make such a language an official language. So it is important for members to note that. In terms of the legal framework, our constitution contains a multiplicity of language rights. Everyone will be aware of the fact that we have 11 official languages, and there's a constitutional obligation on the state to take practical and positive measures. So in other words, the state must be proactive in elevating the status and advancing in particular the use of the 9 indigenous languages, so excluding English and Afrikaans. Then we also have a Pan-South African Language Board that is established in terms of the Constitution, and their mandate is to promote and create conditions for the development of all languages. So that mirrors the constitutional provision. And then also specifically to promote and create conditions for the development of sign language, the Khoi, Nama, and San languages, which are not official languages. And then lastly, also to ensure respect for all languages commonly used in the country, including languages used for religious purposes. So these would be languages that are not necessarily native to South Africa. They may include languages like Urdu, for example, that is spoken by a large part of the Indian population in the country. Then there are many other language provisions, Chair. No person may be unfairly discriminated against on the basis of language. Every person has the right to receive education in an official language or any other language of their choice, where it's reasonably practical. A community has the right to use a language of their choice. accused persons have the right to be tried in a language of their understanding. And then, of course, the Constitution also mandates that national and provincial government must use at least 2 of the official languages, taking into account usage, practicality, expense, regional circumstances, and the needs and preferences of the population or the province concerned. In contrast, though, local government merely says that municipalities must take into account the language usage and preference of their residents. Then lastly, Chair, we also have specific legislation dealing with languages, and that is the Use of Official Languages Act, which provides that national and provincial departments must adopt a language policy, which indicates the official languages that it will use for government business. And if members are interested, you'll find that all government departments, in fact, have these policies on their websites. So, Chair, from the point of view of academics, it's been said that making a language an official language doesn't necessarily have immediate or practical consequences from simply declaring a language as an official language. And rather, you give legal content to a language in terms of what the language policy of the state is. My own research, Chair, differs slightly from that. I don't think that it's entirely true in the South African context, because the Constitution itself regulates the use of language in at least the national and provincial spheres by requiring that government conduct its business in 2 or more of the official languages. So you can already see there's an immediate impact there that once a language is declared as official, local and national government can then use it for business purposes. However, Chair, notwithstanding that the designation of a language as an official language does have these definitive consequences, it's important to note that the Bill of Rights deliberately refers to languages generally rather than official languages. So by way of example, I mentioned earlier that an accused has the right to be tried in a language that they understand. That won't be limited to official languages. That would be any language. Also, local government may choose any language, irrespective of whether that is an official language or not, so they can take that into consideration when issuing government documents. And that being said, Chair, there's also no reason in law why even a national department, by way of example, may not use another language that isn't an official language. The important thing to note, however, Chair, is that the Constitution obliges the Language Board to promote, and that's the important word here, to promote and create conditions for the use of official languages. And then in addition, they've also added sign language and the Khoi, Nama, and San languages. As regards other languages, it then becomes a matter of respect rather than promotion so much. So while the Constitution bounds one to create conditions for the development of the specifically listed languages, the added obligation means that whilst all official languages enjoy parity of esteem and equal treatment, the same cannot be necessarily said for what I'm going to term the unofficial languages, say other languages that are spoken in the country. Chair, the legal treatment of a language is closely linked to the status of that language in society. The mere recognition of a language as an official language is said to have important psychological impacts. And this accords with the view that when government recognizes the language of a minority as an official language, it also thereby acknowledges that minority's right to maintain its identity, because we know that identity and language are so closely linked. It's also accepted that where languages enjoy official recognition, they are proven to be more likely to grow and therefore exist for a long time to come. Chair, I'm not going to go through Article 27. That was just included just to give a little bit more context, but I don't think it's important for the briefing. But I want to give some examples of how, of when a language is declared as an official language, what sort of additional positive impacts that may have. So an easy example is the Broadcasting Act, which specifically mentions that there must be a range of broadcasting programs in official languages. So that means that you would find on television and radio all 11 languages, different programs, news items, and so on. There's no impetus here for a public broadcaster to make any effort to promote the language or culture of a people whose language is not an official language, in this case, the Kilovedu people. Of course, nothing prevents the SABC or any of the radio stations from including programs in that language, but there's no legal obligation for them. Then similarly, Chair, the right to be educated in one's mother tongue is subject to the limitation that it's reasonably practical. So this is despite the fact that research shows us that mother tongue education achieves the best outcome for students and it allows students to compete fairly. But in the case of a non-official language, it's not going to be reasonably practical to give effect to the right to be educated in that language, simply because there's not going to be sufficient educational materials such as textbooks, teaching guides, etc., that allow this right to be exercised. Because remember, the test is reasonableness. So I can't argue that I want to be taught in a specific language, but then there are no textbooks or no material that allow me to be taught in that language. However, once you make a language official, the flip side is that it's now creating some obligation on the state to positively promote that language, so to invest in that language. And also, Chair, no doubt it also then attracts private sphere investment. So you're going to have publishers now willing to publish in a language because it is now declared an official language. So, Chair, rather than focusing on the fact that the Constitution does say that we shouldn't discriminate against anybody on the basis of their language, regardless whether they speak an official language or not, the questions that the committee should be asking is whether the Kilovedu language and culture should be afforded the same protection as that of other minority languages, which are official languages, and what the consequences are if the status of this language is not elevated to an official language. What would be the possible consequences of that? How would it affect the cultural diversity and history of the nation as a whole? Chair, in section 24 of my opinion, if the committee secretary can just move upwards, it's 24. What I've done there, Chair, to try and assist the committee, because at the end of the day, Chair, this is a policy issue. It's not so much a legal issue, it is a policy issue, but what I have tried to do to assist the committee, Chair, is to come up with a list of non-exhaustive factors. So these are just some of the things that I think that the committee can take into consideration, and of course you can add to the list. But in taking your decision, Chair, things that you'd want to look at, for example, is the number of language speakers. But here, of course, we'd have to take into consideration the fact that we also have other official languages in South Africa where the number of speakers is not necessarily large. So it's a small portion of the population, yet that language may still be an official language. Then to look at the geographic location of the language. Can the needs of the community be met at a local level, or is provincial and national recognition necessary for people of that language to access political, social, and economic spheres? The extent of disadvantage in respect of language rights, the preference of the community. Does the community want the language to be declared an official language? If so, why? And if not, why? Whether the state has the necessary resources to practically promote the language, because official recognition alone is not going to have a major impact. It's going to require ongoing effort after recognition. And then the distinction between this language and other languages. So it's important to consider whether the language is a dialect, and there are maybe perhaps other official languages that are similar, and which these speakers can therefore understand and converse in and interact with the state, so that their rights can be realized through other similar languages. And then the extent to which the language has developed and is further capable of being developed in a written form. And here I remind the committee of the fact that in the submission, it was noted that there's already some progress being made in ensuring that the language is now captured in a written form. Where language is insufficient, it becomes difficult for government then to execute its obligations. So, for example, you need to have certain forms translated, bills translated at a parliamentary level. If the language is not sufficiently developed, it then becomes almost impossible to then comply with those requirements. And then what is the risk of the language becoming obsolete? And how is this going to affect the preservation of that culture? In way forward, Chair, so again, in conclusion, is the fact that this is certainly a policy issue, but it's a policy issue that does carry serious legal consequences. And those consequences in turn contribute to the sustainability of the language and possibly even the culture and tradition of the speakers. So there is quite a bit of academic writings on this, that where language isn't protected, the entire culture then suffers as a result thereof. So the policy can't be divorced from the legal issues completely. The committee has opened to it four possible means of addressing it. The first is to simply allow the status quo to remain, meaning that the Kilovedu language is not recognized as an official language. The second is to simply include it in the list of official languages and then leave it to the state then to develop the language in terms of the other constitutional obligations, and the Pan-South African Language Board to do the same. The third, Chair, is to possibly consider an amendment to Section 5A of the Constitution. And you'll recall that I said that the Pan-South African Language Board must promote and create conditions for sign language and the SAN languages. Those were in addition to the official languages. So it's possible to give this language slightly more status by including it in that list, therefore now making it obligatory on the language board to promote the language. Lastly, Chair, the committee can consider whether Parliament needs to amend any existing legislation dealing with language, or alternatively introducing new legislation aimed at directing language policy to specifically promote non-official languages. So is there any way that we can influence that? And then lastly, Chair, I just want to note that this matter is an emotive matter, and the committee must be sensitive to that and aware of that. As Noam Chomsky said, Chair, a language is not just words, it's a culture, a tradition, a unification of a community, a whole history that creates what a community is. All of that is embodied in a language. So in consideration of the matter, the committee is urged to be sensitive to that as well, Chair. But certainly there's no legal obligation to declare it an official language. Thank you very much, Chair.
Thank you very much. I think the opinion is noted. Can we move to the fourth one?
Greetings, members, once again, and Chairperson and the co-chairperson, and to everybody. Thank you, Chairperson. The name is Pumelele Ngema. I had asked for sharing rights. I don't know if I've been given, Chairperson, so that it will be easy for me to fly through and go through the opinion as I pull it down. If not,
You
Chairperson,
asked for what? You asked
for
for what?
sharing rights, for screen sharing rights, Chairperson. But if it's not possible, the secretary can put the opinion up, and I'll just quickly go through what we had said.
I've given her the sharing rights, Chairperson. She is a co-host. She can proceed.
Yeah. No, those who know have given you the right. I wouldn't give you because I didn't understand. Proceed.
Thank you, Chairperson. Chairperson, this is the opinion I'm speaking to. It was prepared and sent through on the 30th of November 2020, as you can see there. And it is an opinion on the issue or the request that we got from the South African secular organization that wanted to request this committee to change what appears in the preamble of the Constitution, Chairperson. I just want to quickly read the parts which the submission is related to, Chairperson, while I move up with the opinion. Chairperson, it is the last part on our Constitution in the preamble, which read, "May God protect our people, Kosikeleli Africa, Murena Buluka Sichaba sa Yesu, God Sien Said Africa, God bless South Africa, Mudzimu Fatuzeta Africa, Kosikatekisa I Africa." Chairperson, the South African Secular Society submits that the Constitution in its preamble glaringly is in conflict with Section 9 of the Constitution. And that is basically the request that the president of that organization, Mr. Rick Rappenheimer, is saying this committee must look into it and see if there could be a review in the preamble of the Constitution, the final one. My colleague Chairperson had already pointed out that there were two crucial judgments that sought to certify the final provisions of the Constitution, and that is the first and the second certification judgments, Chairperson. That being said, Chairperson, what we have submitted in our opinion is that, firstly, the submitter has pointed out that they are making an argument that Section 9 and the preamble are in conflict and they are not speaking in similar terms, because Section 9 of the Constitution provides equality clause that everybody, either before the law and in any other thing, is equal before the law. However, Chairperson, they are also saying then, because of what appears in the preamble, there is then a form of discrimination that appears, because the minority that has non-religious confirmation in any way are disregarded. However, in light of the submission, there is no evidence that was given to be proof and evidential proof that actually these are discriminations that are happening in respect of the non-religious communities or people that accord to no religion at all. Chairperson, in our, without going through the overview of the submission as it appears in paragraph 3, Chairperson, what we've noted when we looked at the submission is to see that the submission does fall into the following provisions of the Constitution. It's Section 9, as I've already pointed out, Chairperson, which is the equality clause and the clause that prohibits any form of discrimination, and the grounds are listed upon which no one must be discriminated against. And the ones that are highlighted there related to this issue are the grounds of religion, grounds of conscience, grounds of belief, grounds of culture. And then the second provision that appears, Chairperson, to be of issue is Section 15. And Section 15 is the right to freedom of religion, belief, and opinion in the Constitution, Chairperson. And the other freedom that is a right mentioned in our Bill of Rights, which is impacted by this submission, is Section 16, which is the freedom of expression. In Section 16(1)(b), it is pointed out there that it provides that everyone has freedom to impart and receive ideas or information. And we believe the submission is related solely on maybe a feeling that they may be restricted or not having space to share their information or ideas, though that does not appear out of the opinion. So it's more of, as I said, there is no proof or evidential evidence of the allegations or whether there is actual discrimination. That said, Chairperson, they then make a reference to God, or God that if the preamble is making a reference to God or gods or any form of divinity, the submission goes further to say that is an acronym and it is no longer having a place in this country, especially in light of what we've seen with COVID-19 and the lockdown and everything that government has done in light of COVID-19. And what has happened because government relied scientifically rather than relying on the beliefs or understanding of those that are having beliefs in God or gods or any form of divinity. COVID-19, they are using it as an example which showed that there is no existence of God or anything that believers should be believing would be of assistance. Chairperson, I've already spoken on the legal framework by outlining all the relevant provisions in the Bill of Rights. The Bill of Rights in our Constitution is giving us both fundamental rights and freedoms and liberties, while it also further clearly stating out what are the fundamental human rights that need to be protected and cannot at all be abrogated, no matter what are the circumstances. So, Chairperson, I want to just read the part in the final certification judgment where the court, as I said, my colleague already touched on this, spoke about the constitutional principles that are 34 in number, and there are specific ones that relate to this matter. But the court said in one paragraph, it wished to conclude this judgment with two observations. The first is to reiterate that the Constitutional Assembly has drafted a constitutional text which complies with the overwhelming majority of the requirements of the constitutional principles. The second is that the instances of non-compliance, which we have listed in the preceding paragraph, although singly and collectively important, should present no significant obstacle to the formulation of a text which complies fully with those requirements. This was a caveat that the Constitutional Court gave, and having spoken to what the Constitution and the preamble is setting out, it was confirmed that the court found with clarity that what appears in the preamble is actually not so much of a problem. All the other principles that I mentioned in the legal framework, Chairperson, have been spoken to by my colleagues that have come before me, so I will not labor much on that, as well as the breakdown on the Section 9, Section 15, as well as Section 16 and 30 and 31, the related rights that are being part of this submission. But Chairperson, I want to read quickly what the court said in paragraphs 203 to 206 in respect of the preamble and what the submission has said.
Before you read,
yes, Chair.
Can you hear me?
Yes.
Before you read, I am on the border of Zimbabwe. I don't have electricity. My system is dying, so that there is no confusion. I want to ask the meeting to excuse me, and Honorable Tim Mashele will take over, because once the system goes down, and then there is no authority to transfer to anyone. So, honorable members, are you happy with that? I ask Honorable Mashele to chair with immediate effect.
Yes, Chair, we are happy.
Thank you, Honorable Jelen. Honorable Mashele, over to you.
Thanks, Chair. As we proceed.
Thank you, Chairperson, both the excused and the taking co-chair. Thank you so much. I shall continue. This is what the Constitutional Court said, and because I don't want to put any thing or words on what the court said, that's why I prefer to just read as they said it. At paragraph 203, they said a number of objections were raised against the preamble to the new text. Several objectors complained that the words "in humble submission to Almighty God," which appear in the preamble to the interim constitution, are not repeated in the new text. That is said to violate Constitutional Principle 2 and Interim Constitution Chapter 3. On the other hand, another objector objected to the inclusion of the invocation, "May God protect our people," as discriminatory against nine-faced in violation of Constitutional Principle number 3. At paragraph 204, the court went further. These objections are founded on a misunderstanding. The first set of objectors pointed to no constitutional principle which mandates the inclusion of any particular religious reference in the preamble. This is now the court unpacking the objections and making a view. Nor did the second demonstrate that the invocation of a date constitutes any form of discrimination against non-faced which breaches the constitutional principle. Now, the crucial part, the court at 205 said, "We also cannot agree with the contention by an objector that the preamble to the new text, that is the final constitution, emphasizes the injustice of the past rather than equality, non-discrimination and reconciliation, and thereby fails to comply with Constitutional Principle number 3, which mandate that the new text promotes national unity. While it is true that the preamble recognizes the injustices of the past and honors those who suffered for justice and freedom, it also respects, that is the preamble, those who have worked to build and develop South Africa. It affirms that South Africa belongs to all who live in it, united in our diversity, and specifically seeks to heal the divisions of the past and build a united and democratic South Africa." The court said, finally, the tenor of the preamble cannot thus be said to be contrary to the ideal of national unity established in Constitutional Principle number 3. The court held that the objection to the preamble had to fail because it failed to demonstrate that an invocation of a deity constitutes any form of discrimination. The Constitutional Court is the apex court in whole of the system of justice in South Africa. So if this is the finding that the Constitutional Court made when it certified the Constitution as it stands and as it appears right now, we would be in the wrong to advise in any other way. Hence, in our submission, Chairperson, as we discussed and as we point out, we have looked at international jurisprudence, we have looked at our own jurisprudence, and we have looked at the constitutional principles to see if there is any right or anything that is being violated by the fact that there are deities or there is a mention or reference to God in the preamble. And the Constitutional Court confirms the position that as far as they could and they have engaged, there is nothing that they found to be wrong. And again, Section 15 of the Constitution, it does not say what kind of religion must be promoted. All that it does is to open up space and room for whatever belief, whatever conscience, and whatever religion you want to follow. And that being said, Chairperson, we are of the view that and are advising the committee that in light of the submission as presented, and without any evidence that provides or show that there is actual real evidence of discrimination in this instance, the way the Constitution and every other instance by government is being done, it is completely open to ensure the maintenance, the protection, and the exercise of the rights in terms of Section 15. And therefore, Chairperson, our advice in light of this submission, we do not feel there is anything that the committee needs to do in respect of amending or making proposals into the preamble of the Constitution of our country. I thank you, Chairperson, and the members for listening to me.
Thank you very much. Can I check if the co-chair is in the platform before I
Yeah, please continue, Marshall, because I'm cutting on and off. But I'm in the
platform. No. You can take over, Chair. I'll do so when you're not here. Thanks.
Okay. Thanks, honorable members. Then let's take the next presentation. Who's next? Hello?
It's Dr. Lutz, Chairperson.
Is Dr. Lutz? Yes, please, Doctor, come give us the presentation. Thank you.
Hi, Chair. I have it on record that I'm number 8, unless I missed something.
Actually, I didn't got who's number 7. I know you are number 8 and Isaac is number 9. Who's number 7?
Chair.
Who's number 7?
Person, I am number 6.
Yes, that is Viwe.
So Viwe and Jigala, I'm not sure if that's where we are.
Chairperson, sorry, we're on number 5.
We are on number 5.
Yes, so the person who is dealing with number 5 can let me know so that I can give him or her the co-hosting rights so that they can flight their opinion. And
number 5 is Siviwe. Number 5 is Siviwe.
No, Siviwe is number 6.
No, it's number 5 in terms of the way they indicated to me. Okay? So who's number 5? Okay, let's not agree to disagree here. Let's take who's number 5. Can I suggest that the viewer take over?
I'll be happy to do that, Chairperson. I'm dealing with a submission by Advocate Paul Hoffman.
Yes.
Chairperson, if I may, with your permission, I will just switch off my camera, and hopefully the host can hoist the legal opinion.
Chairperson, I would suggest that, okay, is it not possible for Mr. Njigela to do it? I've given him the co-hosting rights, or he wants my.
I'll be happy if you do it, Chief, because I want to do things a little bit in line with the comments that were made about us reading the opinion.
Okay, just give me a second.
Chairperson, while the Secretary is doing that, may I propose that I deal with the opinion under 4 headings, in line with the issue that Dr. Mutseha had raised, that the opinions were circulated. I do not intend to read from each heading, but I just need to highlight the salient features of what we are suggesting to the committee. So I intend to deal with specifically 4 headings. One is the background. Then I will deal with the regulatory framework. I will deal with what our discussions are, and then I will speak to the conclusions. My colleagues before me have already dealt with how we came to be here, Chairperson. It was the request from the committee, so I'm not going there. But I will go to the background only to set out what is the submission that was received by the committee, and what is it that is proposed by Advocate Hoffman. Of course, I suppose everybody knows who Advocate Hoffman is. He's the Executive Director of Accountability now. Dr. Hoffman, in the similar vein as the first presentation we did this morning, proposes an amendment of Chapter 9 particularly to create or establish a new Chapter 9 institution that is supposed to investigate and prosecute allegations of what he terms grand corruption. From the submission, one gets an impression that this proposal has been made previously in the 4th and 5th Parliament, and there has been no consequences emanating from it. But in essence, in paragraph 3, we summarize what his submission is. In essence, this is what he says. The Hawks are not up to the task at hand when it comes to countering grand corruption. Their structural and operational lack of security of tenure of office is the underlying problem, which is exacerbated by executive instead of parliamentary control and oversight of their duty. Now, I think that in essence is the summary of what is proposed. Let's create a special investigative body and a prosecutorial body, but that must be included in Chapter 9 in order to safeguard the independence. Chairperson, if I may proceed to my second topic, which is the regulatory framework. My colleagues have already spoken to the issue of Section 45. I don't think we need to repeat that. But I want to zoom in on the special provisions that relate to the National Prosecuting Authority and to the South African Police Amendment Act that establishes the Hawks and that define the mandate of the National Prosecuting Authority. And I propose to start with Section 179 of the Constitution, which establishes a single National Prosecuting Authority. Subsection 2 of that section authorizes the National Prosecuting Authority to institute criminal proceedings on behalf of the state and to carry out any functions incidental to instituting criminal. Further, the Constitution requires the prosecuting authority to function without fear, favor, or prejudice, which is at the heart of how any prosecuting authority is the principle of independence, impartiality, operating without fear or favor. But it goes further to regulate the functioning of the prosecuting authority and its structures. In particular, Chairperson, if we take it further, in Section 7 of that Act, it empowers the President to establish investigating directorates within the MPA by proclamation in respect of any other offense. Now we proceed, Chairperson, to speak to the SAPS Amendment Act, which establishes the Hawks, what is called the Directorate for Priority Crimes Investigations, and it defines what are the priority crimes, and corruption, fraud are part of that definition of what the Hawks are supposed to deal with. Now, the relevance of these provisions, Chair, is that constitutionally speaking, we already have a National Prosecuting Authority, which constitutionally speaking, again, is given the responsibility of prosecuting all crimes, including fraud and corruption. We have the Hawks established under the SAPS Amendment Act to investigate priority crimes, which crimes include fraud and corruption. So you already have state organs that are created, both in terms of the Constitution in the case of National Prosecuting Authority and the National Prosecuting Act to prosecute on behalf of the state. Then within the SAPS, we have an investigative body, which is already dealing with the issues that are being proposed to be dealt with by this new Chapter 9. Now, Chairperson, what has to be said about this is, what is being proposed at the moment is a duplication of this function. And this is proposed under the guise of enhancing operational independence of both the prosecuting arm and the investigative arm. And Chair, most of the members of the committee will remember that in the past, before we had an establishment of what we call Hawks today, we had what we called the Directorate of Special Operations, which was created within the National Prosecuting Authority. A decision was taken, which was endorsed by Parliament, to separate the investigation from prosecution. Hence the migration of the Hawks away from the prosecution to the police. Now, the committee will also recall that once that move was made, there were constitutional challenges that were mounted against that move, both in the High Court and in the Constitutional Court. And that was in the Glenister judgment. What we have observed was that the issue of independence and protection of the independence of the Hawks was a matter that was considered extensively by the Constitutional Court in the Glenister judgment. And it was found at some point in Glenister 2 that it was not adequately protected. And Parliament was given an opportunity to revisit that amendment, that is Chapter 6A of the Subs Amendment Act, in order to enhance the independence of the Hawks, which was done, duly done. There were challenges after that by the Helen Suzman Nation as to whether it is adequately protected, and we know where that ended. So, Chairperson, we find ourselves in a space today where the same issues that have already been traversed, both in Glenister and the Helen Suzman Foundation, being resurfacing under the constitutional review. And I just want to speak to that again. In South Africa, in our jurisprudence, we have what we call the principle of subsidiarity. What the principle of subsidiarity tells us is that where there is a national legislation which has been passed in terms of the Constitution, where somebody finds that national legislation inadequate in any manner, you file an attack, a frontal attack on that legislation. You cannot appeal directly to the provisions of the Constitution. And we mention this because the principle of subsidiarity finds application in this sense, in this particular instance, that there is an NPA Act which creates the NPA, provides for its independence in terms of operations. You have the Subs Amendment Act, which establishes the Hawks, provides for its independence, and seeks to insulate it from executive interference. Now, if anybody is unhappy about any protections that those two pieces of national legislation provide in respect of the operations of that institution, the attack must be mounted against that legislation, not directly based on the Constitution. And I think that's the space we find in. And then it raises the question, Chairperson, whether here we are dealing with a constitutional review or we are dealing with disaffection with regard to the national legislation that has been created. But there is already a mechanism if anybody is disaffected with the national legislation that exists. There are ways to enhance that independence, operational or functional independence, in the legislation that regulates these two institutions. And I think, Chairperson, that is at the heart of this proposal. But, Chairperson, in our conclusions, we make 2 points. That the issue that is raised with you, it is a policy issue. It is within your discretion to make a decision to do it, fully aware of the implication that it has in terms of the National Prosecuting Authority and in terms of the Directorate for Priority Crimes. So that decision is within your discretion. But what we do as a second point is to caution that in the face of the existence of these special bodies already to deal with the same issues, it will create a duplication within the organs of state to create another Chapter 9 institution. This does not seem to be a constitutional issue. or a constitutional problem, but it's a matter that can be sufficiently dealt with in the legislation that governs this institution, if there is any need for them to be strengthened. And having said that, Chair, we leave it to the committee to make a decision on how it proceeds. But as you may have picked up in the manner that I've dealt, our view is strongly that it is not a constitutional issue. It is more an issue of strengthening national legislation. If the committee at any point is convinced that there are gaps within those two national legislation that needs to be closed. Chairperson, on the basis of that, that will be the summary of what we propose in our opinion and the discussions we are engaging on. Thank you very much, Chairperson.
Thank you so much, Sviwe. But members, there are only 4 issues that has been raised in this presentation. It's just the issue of duplication. Consider the issue of that these matters have been raised even before. There were courts that he quoted as issues that were raised there. And also these matters are matters that are within our jurisdiction that we can deal with it under policies. And we have been warned again to check if we are not just doing some duplication on the matters. Thank you very much for that information. I was trying to summarize what we got here. And then let's get the next speaker, the presentation that will be coming from, this is number 6 that I don't have in my records here. Who's taking number 6 now?
Through you, Chairperson, this presentation we just had is number 6. So now, because number 7 we already received a briefing, unless maybe the committee wants a recap, Mr. Njengana is there, but he once briefed the committee on the 11th of November regarding the equal education. So if the committee is satisfied with that, maybe we can skip to number 8. But it's up to the committee. Mr. Njengana is around, but he's there to specifically give us the last legal opinion presentation. Thank you, Chair.
You can take through the committee just on recap, just to summarize. I've tried to make some summarized in one of these items. If he can just take us through, is he prepared to do that? So that just to recap for members. Hello?
Good morning, Chairperson.
Yes, maybe.
This is Nati Mjengane. My apologies for joining the meeting late, Chairperson. I was caught up in another meeting. And I've just joined the meeting now, specifically to present on the last presentation. With your indulgence, Chair, I would ask that I perhaps quickly just go through the opinion on equal education and maybe brief the committee together with the opinion I'd come to present in the committee, so to say, present last, Chairperson, if the committee agrees.
I think that would be in order. Members, then let's go to number 8, Dr. Lloyd.
Thank you, Chair. Chair, with permission, if I can just ask Advocate Greber to share slides of the committee. The opinion I did is actually one that has 9 submissions. So I'm going to deviate from my colleagues and actually work through slides just to make it more digestible, seeing as it's quite long. Thank you so much.
But you can talk to it. Talk to it. It will be shorter, don't worry.
Yes, I'm gonna. These are all, it's 9 submissions by Mr. Ballard. The first 8 deals with specific, or with which we could identify and link to specific rights in the Bill of Rights. And the 9th issue is a general issue where he had a submission as to the state of disaster. So the first one, can Chair still hear me? It looks like the screen is frozen.
No, I hear you.
Oh, okay, great. Chair, then I'm going to continue. The first one, Mr. Ballard spoke to Section 1 of the Constitution, where he said that organizations such as WHO, the World Health Organization, should not have the power to impose or interfere in South Africa's territorial issues and tell us what to do and how to do it. And Section 1 specifically, I think Mr. Ballard misunderstood the context of Section 1, because their sovereignty is linked to the democracy of the state, and South Africa being a sovereign nation. It's more speaking to territorial sovereignty. So it goes to the principle of equality of states, if you look at it from an international perspective. I'm not sure if you can see the slides, so I don't know if I'm speaking to anything.
We have not opened up the slides. You just highlighted on it. Can you double click on it so that it get open?
I don't have access to that.
Pilot, can you assist? We were seeing the folder. It's just that the folder was not opened.
Otherwise, Chair, I can just speak to it as well. It's fine. Then I'll just follow the route of my colleagues. So
you got it now. You got it now. It's on the screen.
Okay, great. That's perfect. Thank you, Chair. So with that, I think what Mr. Ballard actually was referring to, just that one, please, is the idea of international organizations and our membership to it and the agreements that go with that. And that actually falls more within Section 231 of the Constitution, where we have a dual system where if something happens on the international law, it only finds application or is only bound, or South Africa is only bound by it if it's also part of our domestic legislation. So any membership that we have, it's an agreement, and then if we want to take anything from an international stance into our legislation, nothing happens without there being some sort of a buy-in. So just by pure membership, you can't have a World Health Organization or anybody else, like the United Nations or anything, overriding our constitution. That will not be possible. So to just put Mr. Ballard at ease there, this is not an issue of territorial sovereignty. Nobody can come in, no unelected organization can come in. There will be no undue interference. Section 231 is that safeguard, although it falls outside the Bill of Rights, but the safeguard is there, and there's no amendment required to Section 1 for that purpose, Chair. If I can then just move on to the next slide, please. Thank you. That one deals with constitutional supremacy. In this one, Mr. Ballard is saying that the supremacy of the Constitution must be strengthened, forcing the ANC to justify any actions before that action is taken when possible. If not possible, then within 7 days under an emergency. Now, Section 2 of the Constitution speaks to the constitutional supremacy, and it says that law or conduct inconsistent with the Constitution is invalid. And then any person adversely affected is entitled to judicial protection. So the Constitution gives broad guidelines or broad perimeters in which we function. The Constitution won't give specific situations, where it won't say that a specific party or a specific person must do X, Y, and Z. What the Constitution does is it empowers individuals that if they feel that any action or any law or any conduct by any person, by any organization, or by any law infringes on their rights, then that person can take steps and say, but that is an infringement on my constitutional right. The Constitution is supreme, and therefore then any action taken will have certain protections unless that limitation is justifiable. So in this instant, if in any event Mr. Ballard feels that any action taken in terms of a certain emergency situation, although we don't have a state of emergency at the moment, it's a state of disaster, then that action can be taken to a court, and if that action is found to be inconsistent with the Constitution, it will be invalid. So with regard to the constitutional supremacy, there is no amendment needed to add a safeguard if a person feels their rights have been infringed. Thank you, Pilot. If we can just go on to the next one, please. Thank you. On the third submission, Chair, it speaks to Section 11, which is the right to life. And here Mr. Ballard is saying the right to life must include the right to refuse any form of forced euthanasia. Section 11's right to life is absolute. The Constitutional Court in Makwanyane has stated as much. And what I need to point out here is euthanasia is not legalized in South Africa at the moment. There is court cases going on about it, and the question is is a hot topic, but currently we do not have it as a legalized option. But even if it was legalized, nobody can ever force you to be euthanized. So if somebody forces you to be euthanized, then we go into the realm of crime, because then it's not what is understood internationally as assisted suicide. So to just put Mr. Ballard's mind at ease here as well, the right to life is comprehensive enough that that protection is read into it. It will be the same situation as if somebody's murdering you if it's forced euthanasia, because then you don't fall within the definition of euthanasia in the event that we do legalize it, but currently it's not legalized. So there's this general no-go area on it at the moment, so no amendment required. Then with the next slide. Thank you, Pilot. Section 12 was the next submission. Here, Mr. Ballard said that the inclusion of the right to self-defense and the right to bear arms must be included in Section 12. Section 12 speaks to freedom and security of person. The ambit of the Constitution, or of the constitutional amendment that Mr. Ballard wants here is not clear. He did not give an indication of how he'd like it phrased, whether he thinks it's ambiguous, whether he wants more detail. So at best, we can highlight here that unlike the United States, South Africa does not have this enshrined right to bear arms in our Constitution. They do. We don't specifically indicate that. What we do have in our legal system is a right to self-defense. So apologies for the typo there. We do have a right to self-defense as defense. So if something happens and you are in a situation where somebody is accusing you of a crime and you have this defense to go, but I defended myself in these situations. So we acknowledge that without having to specifically identify it in the Constitution. We also, in terms of legislation and in terms of certain prescribed requirements, allow people to own firearms and use them in safe and regulated manners. So it's not that self-defense is not acknowledged in our legal system. It is, and the right to bear arms may not be a constitutionally stipulated area, but we do have legislation that regulates how and when people are allowed to have firearms in their possession. So that is dealt with in our legal system without it requiring a constitutional amendment. Thank you, Pilot. The next one, please. Thank you, Chair. Through you then. The next submission was with regard to Section 40, the right to privacy. Mr. Ballard said the right to privacy for murderers does not apply because the victim should have more rights than the criminal. The ability to track the most serious crimes using metadata for the investigation. He also wanted that included. Here, it's a complex matter when you deal with the rights of criminals versus victims, because we have a situation of a balance of rights when you look at anything in our Bill of Rights. So if there is a situation where our courts look at whether it's accused persons or convicted persons and all of that, they'll weigh up the rights of the convicted person and the rights of the victim in a certain situation and look whether any limitation is justified. So it's not you can't say just generally that somebody who is convicted or accused, they don't have rights. They do have certain rights as long as there is a fair balance. And if there is a limitation to somebody's rights, that then whether that's justifiable will be determined in Section 36. So just the structure of our Constitution won't allow us to move into that perspective with that absolute no rights issue for accused and convicted persons. With the issue of metadata, just one back, please, Pilot. With the issue of metadata, that's more an operational issue when it comes to the investigation of crimes. That's not something, operational issues on something that we'll regulate in a Bill of Rights. As I said, it's a general, broad framework. We don't give the details of the operational issues. So that's something that in practice and maybe in regulations can be regulated, but not something that requires an amendment. And just the next one, please, pilot. Thank you. With healthcare, Chair, through you, Mr. Ballard said that the government cannot force a person to be vaccinated against their will. But this vaccination, he then linked again to euthanasia, saying that the provision to opt out of mandatory vaccinations must be part of the constitutional protection. Government control of scientific expert control of who can be euthanized must be illegal. This is up to the individual or the family. Automatically, the default setting is no euthanasia. So I already discussed this issue of euthanasia above, but maybe just to add in general, although everyone has the right to access to healthcare, which is actually what section 27 focuses on, is that access to healthcare and emergency healthcare, that does not prevent anyone from refusing medical treatment as well. So apart from the fact that we do not have euthanasia, the default position is no euthanasia. That's currently there. Nobody can. The statement that he made is slightly confusing to me, but just also to put his mind at ease, when it comes to vaccinations, nobody can force you to take a certain medical health option. Obviously, rights can be limited, and I know that is a discussion that's currently going on with regard to the COVID vaccinations. So in certain instances, if a government takes a certain action, that limitation of section 27 will have to be tested and all of that. But that aside, just looking at what Mr. Ballard has said here, nobody can force, even if we had euthanasia as an option again, nobody can force you to take that option within your health care considerations. If in the event that we have euthanasia ever allowed and that option is there to you, a doctor can't force you to euthanize yourself by form of injection. You have the option to refuse any medical treatment then you so wish. Thank you, Pilot. And if we can go on to the next one. It deals with section 35, which speaks to the due process rights. Here, Mr. Ballard says we must include the rights of a person who is detained under quarantine, as this can be abused. In other words, a person detained under quarantine cannot lose their job, be kicked out of property, lose their income, or vehicle will be blacklisted, etc. Here we're dealing with a slight confusion of issues as well, again, because your section 35 rights, with the due process rights, is specifically speaking within a criminal justice context. So it's not in the context that would be like a quarantine situation, which we associate with COVID at the moment. And in that, then certain other rights will come into play. So governments across internationally have taken steps to prevent people from being kicked out of their property, loss of income as far as government policies can. There has been some supplementation of that and certain grants. So all of that is a situation where policy considerations come into play. So section 35, although Mr. Ballard is speaking to that and linking the detention that section 35 speaks to quarantine, that's a mismatch. You can't take quarantine and link it to a criminal justice process or considerations. So the argument contained in that submission, it doesn't fit within the fair trial principles there, and no amendment can be it just doesn't fit. No amendment is required. But just to say that policy considerations when it comes to loss of jobs, your labor rights will kick in, legislation where necessary will kick in, and your broader structure will provide protection to citizens as far as possible. And the next one then, please. Section 38, with the enforcement of rights. The submission here is that the state must set up organizations within the judiciary to assist people in approaching the courts to report human rights abuses, especially during lockdown and a state of disaster. Section 38 speaks to the standing of a national or juristic person when approaching the court to enforce any rights in the Bill of Rights, whether they're saying that something isn't being done or that whatever is being done is infringement, that then all falls within that Section 38 framework. But within the context of Section 38, it already allows a person seeking redress for human rights infringements to be represented by civil society. So all the NGOs out there, they work to assist people who don't necessarily have the means for access to courts to get there. You get public interest litigation. You get all of those are allowed within the scope of Section 38. But what's also already within our legal system is Legal Aid South Africa Act, which addresses the issue of legal expenses as it relates to access to justice. The Constitution also makes provision for access of rights to be protected via the South African Human Rights Commission, which is Section 184. And the Public Protector, where you can lay a complaint if you feel somebody within the government has done anything to infringe on rights, Section 182. That's just two examples. You also get for, if it comes to your labor rights, you get the CCMA. So our government has made or put in place certain systems within which people can gain access to protect their rights, to make that access to courts approach easier when there is a rights infringement in the Bill of Rights. So it might not be specifically stipulated in the enforcement of the rights, which is a broader provision within a broader a broader scope. But within that scope, in our legislation, detail has been given to that, and as well as in other provisions in the Constitution where certain, like I said, the South African Human Rights Commission has been created to deal with issues, and no amendment is required in that either. And then just the next one, please, Pilot. Thank you so much. So Mr. Ballard then, in the general last submission, had concerns with the state of disaster regulations. He raised a list of concerns. He didn't specifically link it to any provision of the Constitution, so we don't necessarily have an idea of how he would like us to identify the amendments. He didn't give us enough detail with that. But his concerns, what we could determine, mostly speak to the implementation of legislation and regulations, and here and there, understanding of the connection between them. So concerns related to the need for constitutional limitations. As I explained, the Constitution already has this system of checks and balances and limitations that come into play when somebody's rights are infringed or they feel something has not been done where there is a constitutional obligation. So those constitutional limitation needs are in there. They just activate as context to context and case by case. He also said that the judicial and parliamentary oversight must be there to prevent abuse of power. That's already there. The Constitution gives power, gives the legislature and the judiciary certain sets of powers to prevent abuse of powers, and one of those primarily ones for Parliament is oversight. So that is already there. It just doesn't fall within the Bill of Rights scope. It's in provisions in the Constitution that deal specifically with the powers of Parliament. He then also said that suspending Parliament and the judiciary during lockdown is unconstitutional. Parliament and the judiciary wasn't suspended, but if that were to happen, yes, there would be certain considerations of unconstitutionality that kicks in. But again, the Constitution has certain safeguards to make sure that the powers, the three legs of government, the executive, the legislature, and the judiciary, have certain checks and balances over one another to prevent that there is an imbalance of power in the exercise of their constitutional duties. He also says that civilians are stakeholders as rules affect them. Indeed, we are as voters stakeholders, but we also have a system of representative government. So the representatives you vote for in a parliamentary system, they will ensure that, or they will look out for your rights. We have that idea. Also that any limitation, as I mentioned, if it is unjustified and can be taken to court, so that also is there. So on the one side, you have representative government, and on the other side, you have Section 36 that looks whether a limitation is justifiable. You have 38 that allows you to access the court if you feel that there's an infringement of your Bill of Rights, so that is already there. Yes, if you are a stakeholder, and if you feel that somebody is not acting in your best interest, then you can take certain steps. He also said the transparency of any external experts used. There must be transparency in that. We have a right to access of information. So at any stage, if somebody feels that they don't have the necessary information or that is not being shared, there are avenues to follow to get information. It must also just be said that the Constitution has values of openness, responsibility, and accountability that underlies its framework. And that also comes into play. So transparency is there. If anybody feels that somebody's hiding something, they can take the necessary steps to find that information, and those avenues do exist. He also said the military cannot be used as an enforcement tool as their powers fall outside the Constitution. The Constitution in sections 200 to 204 actually deals with the military. So that falls outside the Bill of Rights. It falls outside the scope of the current exercise of the Constitutional Review Committee, but just also to put Mr. Ballott's mind at ease, the Constitution does deal with the military. It doesn't fall outside the scope of the Constitution. And then that sections are read with the Defence Act. And if the military is used in certain circumstances of state of disaster, and how the president can deploy that, then the African National Defence Force, that's then the constitutional principles read with the Defence Act to get implemented. So, Chair, that is, oh, I'm quite out of breath, I'm sorry. That is the 9 submissions by Mr. Ballot. I don't, from a legal perspective, see anything that triggers a need to amendment, but it's for the committee to decide whether they think that anything needs to be further communicated to a different committee or is sufficiently addressed as I have indicated. Thank you so much.
Thank you very much, Doctor. You have dealt with quite adequately with all the issues: sovereign, constitutional, supreme, security of personnel, rights to privacy. But finally, all these matters, you recommended that there is no need for the constitutional amendment on it. Thank you very much, Doctor, for your presentation. We will consider your point when we are discussing. Then let's take Isaac. Am I correct? Isaac, are you ready?
Yes, Chairperson, I am ready.
We will be very pleased if you can present your document here.
If the committee secretary could please flight the document.
Chairperson, I do not have the document here. Perhaps maybe she can flight it from her side. I don't have a specific document from Mr. Ballot.
It's 140 of opinion number 140 of 2020.
Yes.
I also don't have access to it because I'm using an iPad.
So what are you gonna do? Are you gonna send it to us? But meanwhile, you talk to it.
Okay, let me just try to send it to Chair.
You're saying you've got 140 slides, huh?
Thank you, Chairperson. I have sent it to the committee secretary. Do you want me to proceed or do you want me to wait till it's flighted?
Now that you have sent it, I think let's proceed in the interest of time as well. Let's proceed, talk to your slides, but Pilot meanwhile is trying to catch it up as to how far we have gone with the issues. Yeah, there
Yes.
it is.
Yes, thank you, Chairperson. I will proceed. Chairperson, we also received a second submission from Mr. Justin Ballot, and in this submission, he raised 2 issues. The first one is that he requests that the Constitution be amended to include some kind of protection for officials to refuse to follow instructions if they believe that those instructions are in violation of the Constitution. And his second submission is that he requests that the Constitution be amended to include the right not to self-incriminate. So, Chairperson, dealing with the first issue, that is protection against unlawful instructions, I set out the legal framework in the opinion, and that is paragraph 3. So I deal with this section 1C of the Constitution, which provides for the supremacy of the Constitution and the rule of law. Section 2 of the Constitution deals with, it says that the Constitution is supreme and any law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. If we go further down, we just say section 195 of the Constitution deals specifically with public administration, as his submission relates to public officials. So section 195 sets out the basic values and principles governing public administration. Further down, I refer to section 197 in paragraph 6, and 197 specifically deals with the public service. Section 3 of the Protected Disclosures Act is also relevant to this opinion. So, Chairperson, I will just refer to all of those particular sections in my discussion. So I state the Constitution prescribes various obligations and principles that apply to everyone and to public officials specifically. In terms of section 1C, one of the founding values is the supremacy of the Constitution and the rule of law. Section 2 of the Constitution provides that any law and conduct inconsistent with it are invalid. All public officials are therefore bound to act within the confines of the law, and any action taken outside the law is invalid. Specifically, section 197 deals with public administration, and it sets out the values and principles enshrined in the Constitution. I refer to section 1971, which provides that the public service must loyally execute the lawful policies of the government of the day. So further in paragraph 10, I state there are also specific legislation that governs the public service. So the Constitution sets out the framework which requires public officials and servants to act within the confines of the law, and the Public Service Act specifies specific duties on public officials when they are conducting their duties. For instance, the Public Service Act, which places a positive obligation on an employee to abide by the legislative framework and to report irregularities to a higher authority. Section 16A of the Public Service Act provides that disciplinary action must be taken against a public servant for failure to comply with this act. Further, we have the Public Service Regulations, which state that, which are issued in terms of the Public Service Act and require, amongst others, that public servants abide by and strive to be familiar with all legislation and other lawful instructions applicable to his or her conduct and official duties. Regulation 13E requires public servants to report to the relevant authority fraud, corruption, nepotism, maladministration, and any other act which constitutes a contravention of any law and any other matter, which is prejudicial to the interest of the public, which comes to his or her attention during the course of his or her employment in public service. So, Chairpersons, as I indicated, the Public Service Act provides specific duties for public servants. We also have the Protected Disclosures Act, which protects employees who are making a protected disclosure where they come into, where they have knowledge of illegal activities or irregularities. And the Act provides a procedure for employees who wish to make a disclosure and protects them from any occupational detriment. So, Chairperson, in considering all those matters, in paragraph 12, I said, while the Constitution does not provide a specific protection for public officials who refuse to follow an unlawful instruction, it does place a positive duty on all public officials to act within the law. The Public Service Act and its regulations also place an obligation for public servants to act within the law and to report unlawful action. The Protected Disclosures Act provides procedures for employees to make protected disclosures regarding criminal or unlawful acts in the workplace and protects the employees from occupational detriments. So, Chairperson, in concluding this particular submission, our view is that the submitter does not state specifically how he wants the Constitution to be amended, but it's our view that we have existing legislation read in light of the Constitution, which provides protections and for public officials who do not wish to carry out an unlawful instruction. However, while we have the view that there may be merit in the submission, the legislation may be the best place to start with. So instead of starting with amending the Constitution, we are of the view that you can do so you can provide additional protections to public officials by amending the existing legislative framework. However, if the committee is of the view that a specific provision must be included to protect public officials who refuse to follow unlawful instructions, the committee may consider such a proposal as it is a policy decision within the ambit of the committee. So, Chairperson, that is our opinion on the first submission Mr. Ballard made. The second issue deals with the right against self-incrimination, and Mr. Ballard requested that this right be included in the Constitution. In paragraph 16 of the opinion, I set out the legal framework that currently exists with regard to the right to remain silent and the right against self-incrimination. So section 35 of the Constitution provides for the rights of arrested, detained, and accused persons. And in paragraph 17, I state the Constitution protects the right against self-incrimination in both the arrest and trial phase of the criminal justice process. At the arrest stage, section 35(1)(c) of the Constitution provides that an arrested person has the right not to be compelled to make any confession or admission that could be used in evidence against that person. At the trial stage, section 35(3)(j) provides that an accused person has the right to a fair trial, which includes the right not to give self-incriminating evidence. Further interrelated to the right against self-incrimination is the right to remain silent. Section 35(1)(a) of the Constitution provides that an arrested person has the right to remain silent. Section 35(3)(h) provides that an accused person has a right to a fair trial and a right to remain silent and not testify during proceedings. In light of these specific provisions in the Constitution in section 35, it is our view that the Constitution already provides for the right against self-incrimination. We therefore recommend that the committee write a letter to Mr. Ballard to inform him of the existing constitutional framework that protects those rights. Chairperson, that's my opinion on the two submissions received from Mr. Ballard. Thank you.
Thank you very much. In essence, there are two issues that we have dealt with. Where the first one, there were no specifications as to how he wanted us to deal with the issue of the constitutions. The second one, you advise us to say Section 35 mostly deals with all the issues that are raised on the second category. If I'm listening quite carefully to you. So there is it, members. We now got the last presentation. The last presentation will come from, remind me, Pilot? Can I be reminded, Pilot?
It's from Mr. Mjangan.
Yes, Mr. Mjangan. The platform is yours. Thank you.
Thank you very much. Good afternoon once again to you and honorable members. Morning, two opinions to the committee. And I would request to indulge me to start with the equal education one. Just to recap, I understood from your interaction Chairperson, that members in this one, or members are aware of the opinion. However, they just want to...
Nat, you are breaking, my leader. I don't know. Try
Can
again.
you hear me now, Chair?
Yes, loud and clear. You are okay now.
Thank you, Chair. My apologies.
No problem.
Chairperson, Chair, I had just requested that you allow me to start with the equal education opinion.
I will appreciate that, Nat.
Thank you, Chair. Chairperson, I understand that members have had a view of this opinion, and that you just wanted me to touch on it, on the salient points of the opinion.
Please.
Thank you, Chair. Chair, just by way of background, this matter arising out of this opinion comes from a submission to the committee by a non-profit organization popularly known as the Equal Education. Equal Education. I'm just confused now because I see, yeah. So may I just ask, yeah, please, pilot, just keep the screen on the opinion, please. So Chairperson, the submitter is Equal Education and Equal Education Law Center. They are a non-profit organization. They have proposed, Chairperson, to the committee that Section 100 of the Constitution be amended. Section 100 of the Constitution is that section which deals with intervention of national government in the functioning of provincial government, where the province has failed to fulfill constitutional obligations. Members would be reminded that the Constitution is supreme in terms of Section 2, and that all law or conduct that is inconsistent with it is invalid, and that, relevant to our discussion now, all obligations that are imposed by the Constitution must be fulfilled. So in an instance where a province is failing to fulfill those obligations, Section 100 provides a mechanism for intervention by national government. So in this regard, Equal Education has argued that that section, whilst it is supported, and that in instances where it has been invoked in the past, the submitters are applauding that as a good measure for ensuring compliance with the Constitution by provinces. However, they note that it needs to be strengthened in order to be more effective. And therefore, they are not arguing for its complete overhaul. They are saying that it must be strengthened in order to make it more effective. In this regard, the submitters are citing examples where this section has been invoked in two provinces, particularly in Limpopo, as well as in the Eastern Cape. And they note that in those two provinces where Section 100 was invoked, where national government got involved to assist the province to comply and fulfill its constitutional obligations, those interventions were not effective, or were not so effective, particularly because there was lack of clarity in terms of the state actors which are involved in a Section 100 intervention. And that lack of clarity, the submitters argue, leads to confusion and unfortunately also results in diminished accountability. So in essence, the submitters are saying that the law as it currently pertains or outlined in Section 100 lacks clarity, which leads to confusion as to what state actors must do in the case where Section 100 is invoked, and that sadly leads to diminished accountability in the whole. So the submitters are therefore proposing, Chairperson, that the committee please consider to review and amend Section 100. They cite that making this change or amendment in the Constitution would enhance or address the issues that they have raised. Currently, Chairperson, Section 100 provides that a national legislation may be enacted to outline the roles and responsibilities of all of the state actors in an intervention. However, Chairperson, no such legislation has been enacted. Particularly, the submitters argue, this has not been enacted because the provision in Section 100 currently is discretionary it says that the legislation may be enacted, and that the submitters argue that this is a weakness, and therefore that section must be amended to make the enactment of the envisaged legislation mandatory, that it must be compulsory for Parliament to enact a legislation that will clarify and also strengthen, clarify the role of state actors, but also strengthen the Section 100 intervention where it has been invoked. They also, the chairperson, state that the reporting by state actors in an intervention in terms of Section 100 is not clear, and that an amendment should be made to make it specifically clear that on a quarterly basis, reports of the progress and the challenges experienced in an intervention must be presented to the National Assembly. So sorry, to the National Council of Provinces, chairperson, my apologies, in a case of an intervention. And that they argue, Chair, that the effect of it all, of this envisaged legislation and the clarification of roles, and as well as the reporting on a quarterly basis, would bolster transparency and accountability. That, in essence, chairperson, is what the submission is about, and the arguments that are presented by the submitters in support of their proposal for the committee to review and amend Section 100 of the Constitution. They also argue, chairperson, that Section 100, subsection 2 of the Constitution should also be amended to clarify the role of the National Council of Provinces in an intervention or when an intervention has become necessary. And in this regard, chairperson, the submitters have provided, as can be seen on the screen, the members have proposed or sponsored an amendment, or this is how they envisage that an amendment to that Section 102 should look like, in order, in essence, to clarify the role of the NCOP when an amendment has become necessary. I just thought that I would just preface it with outlining that background for members before I come to what we have opined in advising the committee on this matter, Chairperson. And I would request members to specifically go to paragraph 23 of the opinion in which we express our legal view in respect of this opinion, Chairperson. In that paragraph 23, Chairperson, we say that the guidelines are necessary, Chairperson, as per the definition of equal education, and that the lack thereof necessitates that there must be legislation as envisaged in Section 100, subsection 3 of the Constitution, in order to give effect to what the submitters have outlined, Chairperson. And that the parliamentary committees also in the past have noted the need for this legislation that is envisaged in Section 103, Section 100, subsection 3, Chairperson. And that there needs to be a clarification of powers and responsibilities of the state actors. And we therefore, Chairperson, in essence, from paragraph 23, 24, 25, and 26, support the submission, Chairperson, and we outline the basis on why we say we support it. I would just mention, Chairperson, here that we say in paragraph 24 that enacting this legislation that clearly sets out the powers and functions of the state actors during an intervention would improve service delivery and bolster cooperative governance and strengthen the separation of powers. So that those are some of the bases on which we agree with the submit or support the view of the submitters, Chairperson. We also note that it is not only parliamentary committees in the past that have agreed with the view of the submitters in this regard, but also academics in the name of Professor Mary Metcalf of VET in the past have also noted, Chairperson, that there is a need to enact the legislation that is envisaged in Section 103. And that also the Portfolio Committee on Basic Education, as well as the Limpopo Presidential Task Team and the NCOP Select Committee on Finance have in the past indicated, Chairperson, or called upon Parliament to urgently look into developing the legislation as has been referred to, Chair. And that, Chair, to date, we say in paragraph 28 of our opinion that no such legislation has been proposed, regardless of all of the concessions by all the relevant stakeholders, including Parliament, Chairperson, that Section 100 definitely needs to be looked into for the purposes of ensuring that the legislation that is envisaged in that section is enacted by Parliament, Chair. Chairperson, in paragraph 29, we slightly differ with the letters, Chairperson, because we say where they are submitting that Section 100, subsection 2 of the Constitution should also be amended to clarify the role of the NCOP. In that regard, Chairperson, we note that it may not be necessary. Once you agree that the role of the NCOP may need to be clarified, but we argue, Chairperson, that that does not necessarily require a constitutional amendment, in the sense that if Parliament passes the legislation that is envisaged in Section 100 and subsection 3, Chairperson, then the matter of the roles and responsibilities of the NCOP in respect of an intervention can also be clarified in that legislation without necessarily coming to amend Section 100 subsection 2 just to clarify the role of the NCOP in this regard. Chairperson, that in essence is our advice, Chairperson, that we support the proposed amendment of Section 100 subsection 3 of the Constitution in order to make the legislation that is envisaged by that section mandatory as submitted by Equality and Equality. Chairperson. Thank you very much.
Thank you so much, Nat. Yeah, in essence, you refers us to paragraph 23, where we have dealt with mostly with section 100 and subsection 3, and also section 102. But finally, you agreed with this in terms of the finance and in line with NCOP, and also in terms of your paragraph 28. The members will look into all those issues that has been raised and then take a decision. I think your presentation was quite helpful to the members. We will look into it and come up with a decision. Members, I think now there is no more other presentation. Am I correct?
Sir, there is the very last one. From
the very last one. Okay.
Yes, Chair. There is, Chairperson, the very last one, which is the one Naidu.
You are breaking, my lead. I can't hear you now.
My apologies, Chair. Can you hear me better now?
Yes. Is that Nati?
Yes, it is Nati, Chair.
Oh, okay. Okay, Nati, yes.
Yes, I'm presenting an opinion, Chairperson, on the submission by Advocate Naidu.
Dr. Ramula Naidu.
Yes.
Okay.
Dr. Naidu, Chairperson, is a public interest lawyer who has practiced for over 40 years. In his submission, he states as much, Chair. The essence of his submission is about the process of the appointment of judicial officers, which he argues is not fair and equitable, as it favors the organized legal profession. In this regard, members would remember that in the legal profession, in terms of the regulatory framework, there is what has traditionally been known as the organized profession, being the law society which governed attorneys or the attorneys profession, as well as the bar council, which regulated matters related to practice. And that is known as the organized profession. And there are also those advocates, Chairperson and the committee, who are not members of either of the two, either of the law society or of the bar council. And this is what pertained, Chairperson, before the recent amendment, which organized the entire profession under one regulation or act, which is known as the Legal Practice Act. Dr. Naidu, in essence, that his name was removed from a list of recommended judges to be appointed by the state. He says that the screening committee of the state had included his name as among the
Nat, hello,
Yes,
Nat.
Chair?
Sometimes we find it difficult to hear you. You're breaking. When you are loud, you are so loud and clear, and you also go up and down, some waving. I don't know whether can you position yourself in such a way that you will just hear you throughout.
Yes, Chair. I think it is just the device that I'm using, which has a dysfunctional microphone. My apologies, Chair. I will try to speak as close to it as possible.
Like now, you are so clear. You're quite clear now in that position. Yes.
Okay, Chair. Thank you. So, Chair, as I was saying, Dr. Ramula Naidu complains about his non-appointment chairperson after he claims to have been recommended by the screening committee of the JSC to be appointed as a judicial officer. In paragraph 3, paragraph 6 of our opinion, chairperson, we set out what Dr. Naidu proposes should be changes to the constitution to fix what he says is bias against practitioners in law like himself who are not associated with the organized legal profession. He says, chairperson, that section 174(4) of the constitution must be amended to clarify whether a screening committee of the JSC can, without public scrutiny, remove a nominee from the list of nominations, including clarifying the role of the president in the appointment of judicial officers. He also says that section 18 or 22 must be clarified in order to provide that everyone has a right not to be compelled to join an association in order to practice their trade, occupation, or profession. In this regard, chairperson, he relates to the Bar Council. And he also says that in section 34 must be amended to include private arbitration, and that 34, 171, and 173 must be amended to deal with issues relating to the clocking up of the code roll, which makes it impossible to comply with relevant uniform rules on an urgent basis. And that he also argues that section 178, 1E and J must also be amended to provide for fairness in relation to sole practitioners and independent advocates like himself, and not only members of the bar. And that J must be amended, so that 178, 1J must be amended in order to provide that the president in parliament may appoint members of civil society to those 4 positions as commissioners of the JSC. He also says that 174(5), subsection 5 must be amended to provide that the president can appoint other recommended appropriately qualified persons as judges of the Constitutional Court, even though they do not have judicial experience. And that section 37 must be amended by deleting the connecting word "and" between section 37 1A and section 37 1B. He says that the "and" must be replaced by "or," which is a technical amendment. And then he says that section 42(6) must also be amended to provide clearly for members of parliament to be able to sit in person separately in different provinces. Basically, chairperson, here he is arguing that meetings of parliament must be held via digital platforms, as we are doing now. And then in section 195(2), he proposes an amendment to have an added which would include judicial officers. And then he says section 27(1)(b) of the Constitution must be amended in order to add a provision that the state must ensure within a year that pit latrines toilets are eradicated everywhere in South Africa. And that section 24 and 26 of the Constitution must be amended to provide guidelines for protecting the environment against air pollution, hunting, and poaching of wildlife. Chairperson, we note that in the submission, Dr. Naidu has mainly focused on the issue of the shortlisting of nominees for interviews and recommendation by the JSC, and that he also added these other proposed amendments relating to the issue of pit latrines and the issue of the protection of the environment. But essentially, the submission itself, as members would know, is about the appointment of judicial officers and the process undertaken by the Judicial Service Commission. Chair, under the regulatory framework, which starts from, we discussed it from paragraph 9 of our opinion, we state, Chairperson, essentially, which I do not think would be necessary for me to repeat in this meeting, we state the process that is set out in section 174 to 178 of the Constitution, which is the process of appointment of judicial officers. We set it out, Chairperson, from paragraph 9 up to paragraph 13. And then from paragraph 14 of our opinion, Chairperson, we discuss the issue of judicial appointments. And that, Chairperson, where Dr. Naidu is alleging to have been removed from a list by the screening committee of the JSC, in paragraph 15, Chairperson, we note that the screening committee of the JSC is a substructure of the JSC and not a decision maker in itself. And therefore, to the extent that Dr. Naidu's name was removed, it was not removed as he seems to complain he seems to allege in his submission, Chairperson. It was not removed by the screening committee, but rather it was the decision of the JSC as empowered by the Constitution and the Act to do, Chairperson, and that the internal arrangements of the JSC are a matter that is provided for in the legislation. So where the JSC decides to have subcommittees to do some of the screening work, it is a matter that is the JSC is empowered to do. However, Chairperson, in paragraph 16, 17, and 18 of our opinion, we note that there is credence in the complaint by Dr. Naidu that sole practitioners and independent practitioners are marginalized in respect of appointment, Chairperson, because he also complains that they are also marginalized as it relates to getting the state attorney's office has not briefed sole practitioners. And that, Chairperson, we say to the extent that this is true, it appears that it goes against the spirit and letter of what the Constitution and the law provide on the face of it, Chairperson. However, we are of the view, Chair, that the recourse for the issues that Dr. Naidu raises is not in the amendment of the Constitution, and that there is sufficient provision in the legislative framework in order for Dr. Naidu to seek recourse against what he alleges to be the unfair treatment of sole practitioners like himself, Chairperson. There is no indication, for instance, Chairperson, in his opinion, in his submission, that he has invoked the provisions of the Promotion Act, the PIA, in order to access the decisions of the JSC to see where in the JSC decisions this unfairness that he alleges arises from, Chairperson. And that we believe that if he had undertaken this route, Chairperson, he would be bringing, at least empowering the committee with sufficient information based on evidence, having accessed through PIA the decisions of the JSC to point out these allegations, Chair. And secondly, Chairperson, we also note that the organized profession now is currently being governed by the Legal Practice Act, which establishes the Legal Practice Council, Chairperson, as the regulatory body, statutory body that governs all legal practitioners, including sole practitioners. And that a matter of marginalization of some practitioners by the General Counsel of the Bar, for instance, as he has mentioned in his is rather a matter to be referred to the council, Chairperson, for the council to investigate its veracity and recommend a way forward, rather than bringing it to the committee, Chairperson, as a matter for the review and amendment of the Constitution. And therefore, Chairperson, we say in this regard, Dr. Naidu, as well as all sole practitioners and independent practitioners, must first exhaust all the remedies available to them in law, Chairperson, before they can engage the committee to consider a possible amendment of the Constitution to address some of the issues that they have raised, Chairperson, relating to the marginalization and unfair treatment of sole practitioners and independent advocates. Chair, on paragraph 20, we deal with the submission to the extent that Naidu says that must be amended to protect the environment. In this regard, Chairperson, we say we are of the view that the proposed amendment is not warranted because the environmental right, as it is set out in section 24 of the Constitution, has been given effect to by the National Environmental Management Framework Act, which is known as NEMA, National Environmental Management Act of 1998. And that we say that this framework legislation is sector specific and governs all matters related to the protection of the environment. And it would be best to look into the possible amendment of that act rather than to amend the constitution to provide for the protections that he is talking about. This, Chairperson, is in line with what my colleague, Mr. Njigela, had related earlier on, Chairperson, which is the issue of the doctrine of subsidiarity or frontal challenge. Chair, on paragraph 21, we talk to a proposed amendment. In this regard, Chairperson, we say that our opinion is that to add private arbitrations to section 34 has not been substantiated because, Chairperson, currently section 34 of the Constitution includes all tribunals. It does not exclude, there's not exclusion. It actually provides all tribunals, Chairperson, are provided for in that. And therefore, the extent to which Dr. Naidu says the Constitution must be amended to provide for private arbitrations has not been really argued. And that we do not support that recommendation. And that the recommendation by Dr. Naidu that the courts must use technology in their processes is certainly not an issue for constitutional amendment. Whilst it is an issue that can be debated, it is certainly not an issue that must require constitutional amendment in order to be given effect. On the matter of court procedures and inherent power and the court role, Chairperson, you note in my presentation, I note that Dr. Naidu had complained that the court role is so clogged up, Chairperson, which leads to an injustice as he had applied. In this regard, we are of the view that issue of the clogging up of the court role is certainly not an issue that we support for a constitutional review and amendment by the committee. And that it falls outside of the constitution of the committee anyway. Chair, when it relates to the issue of the composition of the JSC, in which case Dr. Naidu recommends that section 178 of the Constitution be amended. Chairperson, we know that the inclusion of civil society in the composition of the state remains an issue of policy, which the committee may consider in light of what Dr. Naidu argues, because he is of the view that addition of civil society as members of the JSC would enhance the work of the JSC and also the accountability in the work of the JSC. In this regard, Chairperson, we say that our view is that this is a policy issue which the committee may decide. He also proposed the amendment of section 37, Chairperson, and in this regard, we say that the proposal to amend 37, delete and replace it with or, and to clearly outline the powers of the president in a state of emergency is also one of policy which may be considered by the committee, whether it warrants an amendment. We do also state that it is, however, important to note that the submission has not fully substantiated, Chairperson, why it is that there must be this technical amendment. Chair, on the proposal, which is in paragraph 25 of the opinion, proposal for amendment of section 42(6), our view, Chair, is that the proposed amendment to provide for Parliament to meet via digital platforms, Chairperson, is a moot one. And certainly one which does not warrant a constitutional amendment. Chair, in this regard, you would note that currently we are meeting over a digital platform. And therefore, to the extent that is proposed, it has become moot. In 26, Chair, we deal with the proposed amendment of section 195 of the Constitution. In this regard, is not to say that we also view that it would offend against the principle of separation of powers, which is inherent in the scheme and design of the Constitution. And that matters of the administration of the courts are matters that fall outside of the jurisdiction of the committee. Where he proposes the amendment of section 27, Chair, which is in paragraph 27, our view is that this proposed amendment, Chair, to ensure the eradication of pit latrine toilets is not properly substantiated. In any case, Chairperson, we are also of the view that such a matter is a matter that is governed by policy as well as legislation and that is implemented at that level, Chairperson, and one that does not necessarily require the committee to review and amend the constitution to provide for the eradication of pit latrines, Chairperson. And we are of the view that an amendment of the said section is both unnecessary and unjustified, as this issue is a very important issue, but an issue of. We conclude, Chairperson, our opinion by noting that if the committee is in agreement with our views, as I've just expressed them, we would recommend that a letter be written to Dr. Naidu to inform him that the matters that he has raised in his submission, save for the two policy issues which we have outlined, would be referred to various relevant committees within Parliament in order for those issues to be looked into, Chairperson, to assist some of the issues that he is raising. Chairperson, lastly, we note that all of that we say in our opinion, Chairperson, is possible guidance to the committee, and that the committee would have to just make its own decision based on the advice that. Thank you so much, Chairperson. That's all.
Thank you, Nat, for the lengthy presentation, but we appreciate that you were dealing with step by step, which will enable the members to be easy to deliberate on these issues. Colleagues, here is the presentation that is given to us. Earlier on, I proposed that, what we need to do, members, we can go two routes. One is to discuss these matters now and adopt it. The second way is that now that the presentation is being presented to us, Sisanda can summarize to it, give us a summary to it, because we're given it in detail, do some summaries, and then adopt it one by one until we came to the end. I don't know, I'm putting to you, members, over to you now. You can ask, firstly, seeking clarity questions, and then we choose as to how are we going to deliberate on this report or on these views that has been presented to us. Thank you very much. Let me hand it over to you. Are you there, members? Hello?
Okay.
Yes.
Hello, Chair.
Yes.
Yes. Now I hear you present two options, and I was also asking myself after the presentations, how are we going to process this information? It's presented by different lawyers, but all of it coming to one person. That person is me. You see, I must still process it. And I think they've done very well in teasing the issues out and guiding this committee. Now we're discussing process. I don't know. I think it's the first time. I don't know, but they will correct me. It's the first time I'm a member of this committee, but they've been around and advising the previous committee. I thought I want to think, is this the first time that this committee receives so many legal opinions in one sitting and expected to make a decision without having listened to the submitters? I don't know whether this committee ever thought of creating a platform where we invite the submitters one by one to come and make a presentation and elaborate on the points that they're making. I know that having something in black and white is one thing, but understanding where the person who's drafting it is coming from when he elaborates, and you get new nuances which may even improve the way you respond to it, or the way I would respond to it. But we do not get that benefit because they're not here before us to make a presentation, and so that we understand the issues from their point of view. It leaves me with a question. Would I think it's sufficient for me to conclude on what they've written, that now that I've received the information from the legal opinion, I know exactly what he wanted to say? I don't know. And maybe my question, Chair, to the legal colleagues is, can they advise us how to process this information? We've received the information, but how to process it? I know there are cases where they say, this one, we don't agree. And yes, we don't agree. And but must that be the end of the story? This one we agree partially. Must that be the end of the story? I don't know. And will the person who made the submission think that we have been able to apply our mind effectively on what he says, or will still feel that if I had been granted the opportunity to come and do the presentation, maybe the legal opinion would not be what it is now. I don't know, but they're here to advise us. Let me leave it at that. Thanks.
No, thanks, members. Maybe in terms of the process, I will then attempted to call in Sisanda because we have adopted the program which also dealt with some of these processes, but maybe I raise a difficult way of dealing with it after proposing the two options. But nevertheless, Sisanda, she is in the platform. Can you take us out, Sisanda?
Thank you, Honorable Chairperson. As recommended by Honorable Gondwe earlier on in the meeting, members would need to interact with the information that they've received, and it is also up to the committee to decide to call the submitters to come and present to the committee. Ordinarily, the committee always holds public hearings where it affords the submitters an opportunity to also answer clarity-seeking questions, which are then coincided with the legal opinions which members have received in order for members to arrive at their decisions. However, this process of hearing the legal opinions first allows us as a committee to first tease out the matters that don't necessarily require us to call the submitters. And we will then only summarize and call the ones where we feel that there is a possibility that the Constitution might be amended. So in the deliberations as a committee, the committee must decide then the ones where it is a clear-cut decision that the provisions are provided for in national legislation and it does not necessitate a review and amendment of the constitutions. We would then eliminate those and write back to submitters and advise them the same. And also in instances where we will refer matters to the committees that deal with the subject matter, we will then also write to people. But where is the submissions where they are necessitating or there is a close desirability in them amending the constitution, The committee normally does call the submitters, like we did with equal education. If the committee will remember, equal education did present to the committee after Nati had presented the legal opinion on Section 100. So it is definitely up to the members to deliberate and decide on the strategy forward. But both sides of stories must be heard. We must hear the submitters. It is also recommended that we get legal advice, and where the committee feels it's necessary, we can also call the relevant stakeholders like the South African Pen Language Board, or any stakeholders who are relevant with regard to the proposal that's made in the submission. And then the committee can come to a decision on the desirability, having taken into consideration the stakeholders, the submitters, and the legal advice received from Parliamentary Legal Services. I don't know if that assists, Chairperson. Thank you.
I think I'm assisted as well. You know, that's why, members, I was proposing to say, let's have one high-level summary of all the presentation that we've got it today. Like you've got a submitter, a column of a submitter, the legal opinion that we have got today. Then we discuss the issue of a desirabilities of that matter. And then we took a decision in that submission. After Sisanda has summarized all of those that we find is undesirability, able to be part of this, you will select those. And all those that still need to be reprocessed. I think, members, we can deal with this process in that way. Will it that assist this members, the committee, that proposal?
Supported, Chair.
Who's this one?
Chairperson, it's me. Sorry to take you back. There is a submission that we did not receive, which was legal opinion 5 on the table. So I'm not too sure whether from legal services who was responsible to give us this submission. I will flight it. Maybe they can give us a view, because maybe when we have to decide, it may pose a challenge. There is this submission number 5. The submitter was Martin van Staden, but we did not receive a legal opinion presentation on this one.
Okay, maybe before that, let's finalize the principle so that we see how we approach this forward. Members, I'm looking at a hand or a figure here. Anything? Remember, we have adopted our program today after the minutes. Okay, I can see.
Chair, no, your proposal is in order, Chair. We agree with it. Let's proceed as you proposed.
Thank you very much. Thank you very much, members. Then let's check this submission 5. Back to you, Pilot.
Okay, Chairperson, we were expecting to receive a briefing from legal services. So I don't know whose responsibility was it going to be, but we did not. Nobody took up the task. Thank you.
Legal officers, are you there? Who's supposed to deal with this one? Anyone can assist me?
Chairperson.
Yes, my lead.
It's a view and
yes.
I'm not sure exactly who that is, because I can't see the opinion. Is it possible for the Secretariat to share that with me so that I can look who must have performed that function? because from where I'm sitting until I see, but we normally put either on the inquiries or at the bottom of the paper the name of the legal advisor who prepared that opinion.
I think we got a name who's supposed to present it. That isn't it, Pilot?
Who?
Chair, I did not get the indication of who was going to present that.
Okay. Person, this is Fatima Ibrahim. I'm assuming, person, that may be the opinion that was drafted by Advocate Frankie Jenkins. Advocate Jenkins is attending the IPU in Spain. I know that he was trying to log on earlier, so perhaps he's lost connection. But I'm assuming that may explain number 5.
I think you are really assisting me. You are really assisting me now. Then, members, if that's the case, we're still going to get it. But meanwhile, let's deal with what is in front of us so that we can have a way forward on these matters. Members, we have agreed that all this presentation legal opinion that is being presented before us, we will have a high-level summary in a form of a graph where we consider that these were issues that were flagged in this submission, and then this is the legal opinion, and then it will leave our space as to what do we do. After Sisanda has summarized all those that they are desirable, will be packed aside, and those that need to be got a letter to be written back to them in terms of those that does not fall, and we see no requirement of constitutional review, then what we'll do, we will write back to them, and then those that we think members we agree to process, we will do so, members. If you feel that there is an item, one of the presentation that you thought it has been wrong categorized, maybe into the other section, we can always look into that and go forward. That takes us almost towards the end of this meeting. Let me check with members if there's anything that I'm leaving out. Anything? I'll start from Sisanda.
I'm covered, Chair. I understand what I need to do for the next meeting. Thank you.
Pilot.
I'm covered, Chairperson.
Members, anybody wants to contribute? I think we all okay. Is the Dr. Matole still there on the platform, Pilot?
No, Chairperson, the co-chair is not on the platform.
It's not on the platform. Then, members, colleagues, legal desk, we really appreciated all your presentation. This presentation will assist this committee to process these matters, and we will consider most of the things that we have said. Now we are clear as to what is expected of us to do and how are we going to deliberate on it. We can promise you that all these matters, we will deal with it according to the way according to the members, how they see it fit, and taking into consideration your inputs, because your input was very helpful, because it was detailing in each and every presentation opinion that was put up there. Thank you very much for the excellent work that you have done for us. We really appreciate it. So may I now, unless there's something that is left out, especially from the website, Michelle? Otherwise, members and colleagues, thank you very much. This meeting stands adjourned. Thank you very much.
Thank you, Chair.
Thanks,
wayivala singekathethi ngezinto ezibalulekileyo.
Thank you, Chair.
Uzayithola ithuba lalezo zinto. Thanks, team members. Thanks, leadership.